Good afternoon, all. This hearing is in the matter of CFI 106-2021 and is being held by way of video conference before His Excellency Justice Michael Black, KC, with the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by DLA Piper, Middle East. Lead counsel is Lord Jonathan Marks, KC. The defendants are represented by Horizons & Co. law firm. Lead counsel is Mr. Riaz Hussain, KC. Thank you, Your Honor.
Thank you very much. Can I just clarify or at least confirm one thing? Can I confirm that I will get a transcript of this morning's argument as soon as possible after? I don't know who'll be responsible. Will the court deal with that, or are the parties to supply it to me?
The court is able to provide that, Your Honor. However, I do believe that the parties have instructed a third party as transcribers.
Okay, so in which case would the parties then please ensure that as soon as there's a corrected transcript, I get it?
Your Honor, Mr. Mackenzie's on screen, and Sir Horizons, and so Sir Chevalier, I'm sure that we're done.
Thank you very much indeed. Good. So you've got 2 hours each. I assume, Lord Marks, that you're going to kick off.
Your Honor, I'm going to kick off. I was rather hoping for 2.5 hours, but the 2 hours is a hard stop.
Well, we'll see how we get on.
Your Honor, thank you. Your Honor, well, I'll start immediately. I'm going to take my submissions in the order of the defendant's closings. So I'm going to deal with the BAM's claim against Affan first, then BAM's claim against Dr. Affan personally, and then the counterclaim after that. Your Honour, at a lot of stages, and because of the shortage of time, I'll simply give you references without taking you to the documents. But I hope to address what we say about Affan's closings. Your Honour, the argument I address first is the defendant's argument that there's no legal basis for BAM's claim. That was an argument taken in the PTR with the note provided, as you remember, just before the hearing by Mr. Hussain. He was saying that we were originally claiming an entitlement to recovery under Clause 6. He said that we abandoned such a claim in opening. And he still says in his closings of paragraph 2.4 that there was no pleaded claim for damages for breach of contract. Nor I think you have our submission quite clearly, that we say that the claim as pleaded in the particulars of claim was and is a claim for damages for breach of contract. It's not a claim brought under Clause C6 of the addendum and never was. And it's pleaded in conventional terms in the particulars of claim. The subcontract and the addendum are set out. The breaches are alleged. The consequences of the breaches are alleged, and the loss is set out. En passant, I say that the loss now claimed of 104 million AED is very close to the damages figure posited by the experts now in CJM4 for BAM's claims. The defendants argue that the amendment that we made at the beginning of the hearing represents a major change. You'll remember it was in paragraph 90 of the particulars of claim. And we substituted for the words less assessed value of the subcontract works recovered from the employer, which we say was an incorrect formulation. The words less agreed price of the subcontract work adjusted for instructed variations. And what we say is that the amendment does no more than set out a correct formulation of a conventional claim for damages, the actual cost to BAM of carrying out the works, putting the innocent party in the position that they would have enjoyed had the contract breaker perform the contract at the contract price by subtracting from that actual cost the contractual cost, which is the agreed price of the work adjusted for instructed variations.
I'm putting it in very simple terms that I can understand. It seems to be common ground that the actual cost of the work was something of the order of twice the actual contract price, and it's your case that Affan has to bear that.
Yes, that is right, and he took the risk of accepting a low price. That sometimes happens. It may have been ill-advised, and indeed it was. But your decision on this claim is who has to bear the effects of that mistake.
Yes.
We say that the stress therefore placed by the defendants on clause C6 is misplaced. And I would point out that where you go through the particulars of the claim, everywhere it's cited, it's correctly cited as providing essentially that all the costs incurred by BAM, including historical costs, running costs, and so forth, would be, and I quote, recoverable against the value of the subcontract works, which is the subcontract price adjusted for variations. So that the only significance of clause C6 to this case and to this claim is that if there were a claim for variations that succeeded, then that would have to have set against it the value of the subcontract works. And that's the point that we took in our skeleton at paragraph 77, and in our closings at section D8 of paragraphs 135 to 137. And no quarrel has been taken with that. So the way our damages claim is put is that BAM was obliged to step in as a result of Affan's breaches of contract under the step-in rights that it had under the addendum, and inevitably paid for the balance of the contract works. And we say there was no prospect of Affan paying for the works. And to Mr. Hussein's credit, he's never suggested the contrary. They were dealt with as contra charges in certificates that were provided periodically by BAM to Affan during the remainder of the works. And you'll remember that there was one particular certificate at page 2722 that was discussed with Mr. Doyle, who explained how that worked. And we say that the payment for the works by BAM was not only the foreseeable consequence, but the inevitable consequence of BAM's exercising its step-in rights. And we'll go through them in a moment. We went through them in opening. And we say that those costs would largely have accrued in any event to the credit of BAM, because they were going to be paid as production costs, running costs, and so forth under the addendum. But they don't necessarily come to exactly the same thing. Now, the defendants say in paragraph 4.2 of their closings that because there was no termination, somehow there can be no claim for damages. And they even say, and I quote, that extra overcosts, which are shorthand for what we claim, under the contract are only recoverable on a termination. We say that's simply wrong. It would be wrong in English law, and it's clearly wrong in UAE law. And the simple reason for that is because termination is a court-imposed sanction, and there can be no unilateral termination, as you pointed out in discussion, and that's the clear effect of Article 267, and it's covered in my closings of paragraph 8 on page 10. There can be no termination except by agreement or by a court order or by a provision of the law. And the concept of repudiation and acceptance, which is cited by Mr. Hussain in his closings, is not a concept of UAE law. Now, BAM could have sought a termination. It could have served notice to terminate under clause 26.1. And the defendants are absolutely right to point out that BAM chose not to do so. And they chose not to do so for all the reasons that are given in paragraph 39 of our written closings. And I invite you to look at clause 26.1c to D on page 1438, which we say would have given BAM the right to choose a termination. But I also point out that that right at the end of that clause 26.1, when you look at it, you'll see, is a right to terminate which is expressly without prejudice to a claim to recover loss, costs, expenses, and damages. And we say that it is clear from the UAE cases that in a main contractor-subcontractor relationship, it's open to a main contractor where a subcontractor is not performing the subcontract works in compliance with the subcontract to take over the works and to claim the extra cost of completing the works from the non-performing subcontractor. And damages can be awarded on that basis by the judge for breach of contract in the amount of the extra overcost of completing the works. And we say that is clear from the report of UAE 446 of 2021, which is a decision of the Federal Supreme Court and is CCL 17.
Sorry, do you want me to turn that up?
Where I can do, I can cite the passage that I rely on. So it's at the bottom of page 2 in the report. You're perfectly, it'll be helpful if you'd look at it eventually, but I can just read it to you now.
Yes, please.
If the subcontractor fails to comply with what is left out, but is what it meant, the requirement to complete the work in accordance with the contract, the contractor may find an alternative subcontractor to complete, or in case of urgency, may execute the obligation at the expense of the subcontractor without a judicial authorization. And then it goes on to talk about delay. The original contractor shall have the right to withdraw the work therefrom, and explain from the contract that therefrom means from the subcontractor and complete it through others. And there's a commentary in SADA in the exhibits at CCL 18 at page 195. It's paragraph 3. Again, I needn't trouble you with that now. But we say that it makes no difference if the main contractor carries out the completion works himself rather than through another subcontractor. And we say that's specifically covered by the Supreme Court decision that I've cited. And BAM's case on this point is strengthened by the step-in rights and powers contained in the addendum, which the subcontractor expressly agreed that BAM should have. We also say that this decision follows as a matter of common sense from the legal structure in UAE, where a termination without court's involvement is not permitted and you have to go to court, so that it makes sense that a default by a non-performing subcontractor right to replace the subcontractor's labour with elsewhere with his own or because the system doesn't leave it open to the innocent party to accept a repudiatory breach of contract. And that, we say, is an important difference. Ron, can you hear me?
I can. I've lost vision, but I can hear you.
I've now lost vision as well. I don't know why that should be. I don't know whether to pause or to carry on.
I'm happy for you to carry on if you are. I can see, in fact, we have a running transcript created by Teams, so I can actually hear you and see the transcript running.
Well, that's helpful. If you could indicate if you stop hearing me, I hope I get that indication.
I will certainly.
Thank you. So we say that that Supreme Court case is clear authority for the recovery of the extra overcosts which BAM claims. And we also say that, for the sake of completeness, that there is clearly a case of urgency here because the contractor is under all the time pressures imposed by the main contract. So the questions for the court are: first, was the defendant in breach of contract, which I'll call the breach question? Secondly, did the claimant suffer loss in consequence of that breach, which I'll call the causation question? And thirdly, what was the extent of that loss, which I'll call the damages question? And those questions reflect the general law in England, but they're also plainly applicable in UAE law. Now, the defendants contend at paragraph 510 of their submissions that because none of the particular breaches can be shown individually to have caused BAM's loss, BAM cannot succeed in its damages claim. To use an example, they say at paragraph 2.6 of their closings that no, BAM cannot show what particular loss flowed from the example they take is Affan's reassignment of key staff or from Dr. Affan's personal absence from the UAE. That submission, we say, shows how narrow and inapposite Affan's point is. Because the fact that a particular breach did not lead to a specific item of loss does not mean that that breach did not contribute to BAM's having no option but to conclude, rightly in this case, that Affan was a non-performing subcontractor and was failing, to use the words I cited from the Supreme Court case, to comply with the requirement to complete the work in accordance with the subcontract. Put another way, the defendant's submissions ignore the nature of BAM's loss, because the nature of BAM's loss is not that it's a loss caused by the individual breaches of the subcontract by Affan. The reality of the answer to the loss question is that BAM, faced with multiple and repetitive breaches of the subcontract by Affan, and having warned Affan to remedy its performance on numbers of occasions, could not secure compliant contractual performance from Affan. It followed that BAM was right to view Affan as a non-performing subcontractor, and was right to take the view that it had no option but to take over the contract of the subcontract works and pay the extra cost of so doing, which in the real world Affan was not going to meet. Well, I'm pausing there. Can I check that you can still hear me?
Sorry, yes, I can still hear you. And you're still being transcribed.
Well, that's very helpful.
Okay.
Your Honour, the fact that Affan took over with the assistance of the step-in rights that had been expressly granted by Affan in the addendum, which took priority over BAM's obligations to Affan under the subcontract, where they conflicted with the addendum, that was a matter for which the addendum was expressly provided. And Your Honour, the 23rd of June letter, which is at page 2714, you'll remember it's out of order because it's attached to a letter of the 11th of May, halfway down, described BAM as being exposed to the consequence of Affan's failure to proceed with and complete the subcontract works. And as a result, BAM is exposed to significant losses and damages, including delay damages. The reference to delay damages is, of course, a reference to the risk from the employer. And then it goes on as a consequence. And, Your Honour, we've set out a table of breaches at pages 23 to 25 of our submissions. And if I may just ask you to look at that to go through the shape of it with you. So that the letters of complaint are set out in the...
Sorry, it's pages 23 to 25 of your closing. Yeah.
Of our closing submissions, yes.
Yes, just bear with me one short. Yes, I have it. Yes.
So that we set out in the first column the dates of the letters, the second column the reference of the letters, which always starts BHH letter and a number, and then the page numbers in the bundle, where they are in the bundle, which I think in respect to the first two pages, first three pages is all of the letters. Some of them are merely the 23rd of June, the ones at the end. And then we set out the description of the breaches and the clauses breached in the fourth column, and some notes in the fifth column. And it's worth looking at some or all of those letters. There are some letters at the end on the third page on page 26 that are not evidenced by correspondence in the bundle, except for the 23rd of June letter. But we say that they're plainly evidenced, and there's not been any issue taken with them. And it is our position that BAM took over the subcontract works effectively, but that doesn't mean that there was any exclusion. And I'll come to that in a moment. What it means is that BAM carried out the rest of the contracts, the rest of the subcontract, and paid for it, and dealt with the finances just as Mr. Doyle described, by way of interim certificates and contra charges. And we say that BAM was right to conclude that Affan was a non-performing subcontractor, that it was in the same position as the defaulting subcontractor in the Supreme Court case, and the consequences for BAM were potentially severe and urgent because they exposed BAM to risk of action by the employer and to the payment of damages to the employer, quite apart from any professional and reputational consequences that would follow from not completing the contract in time and efficiently.
Can I just, sorry to cut short, because we have all of this documentation, and obviously we're at the end of a trial, so I've read a great deal. So can I take a very broad question, which is troubling me, and it's this: let me accept the premise of your present submission that Affan was non-performing.
Yes.
But the question then is, if it was non-performing, why? And that takes me back to the point I just clarified with you earlier. Who bore the risk of the extra cost of the project? Because I anticipate what would be argued against you is we, FM, didn't bear that extra risk. We were starved of cash flow as a result of having to fund matters that should have been awarded to us by way of variation and interim payments in relation to that variation. And so if we were non-performing, it was your fault. What do you say to that?
That's the way that the case may be put against us. But
yes.
This all has to be seen against the contractual mechanism. There was a contractual mechanism for staged payments. Those payments were met. There was a contractual mechanism for variations. That mechanism was not activated at any relevant time. Your Honour rightly suggested that if they were getting an instruction, which we don't accept, but if they were getting an instruction to do different works from those they expected, then they should have said so. And they certainly shouldn't have gone ahead and signed the subcontract in January 2018. They should have been quite clear that that was not, if this were the case, and we say it's not, that was not a matter that should be dealt with by them simply saying, look, this contract is turning out to be more expensive than we thought. Yes, we've made a big error, or not indeed, yes, we've made a big error, but no, it's all your fault because you've changed the ball game. For that reason, we are not taking it further. And they didn't do that. They went ahead with the works on the basis of the offer that they made, of the letter of intent. They didn't claim a variation. There wasn't any stage at that stage that they could claim a variation, but they didn't say anything about it. They didn't object, saying these works aren't as tendered. And so they bore the risk. They didn't operate the contractual mechanism. The scope of works in the letter of intent was absolutely clear. They didn't say what we're now asked to do is a breach of that scope of works. The scope of works was quite clear that there was to be no extra payment over and above 125 million. And then if after the subcontract was signed, if they said the works are entirely varied, they could put in an application for variation. They did none of that. And their payment for variation would be determined in accordance also with the contract. And so they have absolutely only themselves to blame for this. Ron, would you forgive me while I walk across the room and get a glass of water, which I forgot to do earlier?
No,
you
not
can't
at
see
all.
that I'm doing that anyway. Actually, I quite accept. Can anyone still hear me?
Yes, I can certainly hear you.
I can quite accept that Your Honour has hit upon what is a conundrum in this case, if it is the fact that the works were different from the works that were originally planned and tendered for by Affan. We don't accept that for one moment. Our position is that Affan tendered for the works that were actually done, and that they have only themselves to blame for getting it wrong. And that's the subject of, it's the subject of some, at any rate, of the argument on the variation counterclaim. But on the claim, they simply haven't established that they made any legitimate claim for payment under the subcontract or under the letter of intent. There is significantly no claim at all for withholding payment. There's no allegation that BAM did withhold payment, except made orally by, and in his opening, I think, by Mr. Hussain. But there's no pleaded claim that they were entitled to claim to payment which wasn't made. And that really is the end of the argument. And as Rana rightly put to Dr. Affan when he gave evidence, well, why didn't you say on the 2nd of March, if what we were now being asked to do was not what you tendered for? No, I'm not going to do it that way. This isn't what I tendered for. But there wasn't a breath of that. And he then went ahead, and he was asked about this as well, and signed the subcontract on the 8th of January 18 without any objection or suggestion that the works had changed. Ron, if I can come back to the step-in rights,
Yes.
because an important point arises here, and you may get the impression through the closings that there is a very wide gulf between us about the history and about what happened under the contract. Because the defendants now contend that BAM had no right to take over under the step-in rights under the addendum. And in his closings, Mr. Hussain suggested that we were struggling to explain the step-in rights in our opening. And he quoted a passage from my opening, which is at page 156, at line 29. Sorry, day 1, page 56, line 29, through to page 58:14. And frankly, he stops too soon, because you made it clear, if you go on to line 26, that you found the reference to the step-in rights helpful, and we say they are helpful. But interestingly, this argument by the defendants now, to the effect that there was no right for BAM to take over the works, is a completely new line by the defendants taken for this hearing. The defence on this, which is at page 49, paragraph 6.6, is entirely half-hearted, and the step-in rights are not denied. And I would invite you to look at Sir Peter Gross's findings on page 569 at paragraph 9, because he drew attention to the defendant's skeleton for the 22nd of June hearing. And in relation to the addendum, this is at page 239 to 240 in the skeleton, the defendants contended that the addendum actually provided for Affan to be paid for the works completed at the date of the addendum, and thereafter was to pass the role of providing facade panels to BAM, with Affan permitting BAM use of its facilities for this purpose. So the original case was that they expected a step-in. Now, the contract, as we know, includes the addendum. An important provision of the addendum is at clause A1, which gives the addendum the highest priority in order of documents. And the effect of that is that the subcontract provisions take effect subject to the provisions of the addendum. And that, we say, is ignored, that priority, in the defendant's closings, because the defendants take a number of points, citing subcontract provisions that have been modified by the effect of the addendum and the priority given to it. For instance, the right of access of Affan to the site, they cite at clause 11, and they cite that at 3.9 of their closings. That's now subject to B1 of the addendum, and I will in fact read, if I may, clause B1 of the addendum, because it's a very wide clause. The subcontractor will allow the contractor full unimpeded access and use of the subcontractor's staff, labour, equipment, documentation, and any other things required for the fabrication of the subcontract works as completed and not installed, partially fabricated, in the factories as stock, ordered and to be delivered and to be determined, and to the factories and facilities that are required for the fabrication, dispatch and installation of the subcontract works, and so forth. And I'd also invite you to look at, though not now, the undertakings at B2 to 6, inclusive B7, B9, and B10. And yet, he argues that his 3.9 says that his argument is fatal to BAM's argument that the addendum somehow allowed a takeover by BAM, whereby the first defendant's management could be removed from site and the claimant could manage the first defendant's work. Because that submission simply doesn't reflect the facts. BAM indeed had to ensure, was under an obligation to ensure under clause B7 of the addendum, that their management was available. And the narrative in the defendant's closings, which is to the effect that BAM impermissibly excluded Affan from the site, is a complete red herring. The evidence does not establish at all that Affan's staff were excluded from the site. Effectively, Affan's staff were seconded to BAM and remained in Affan's employment. And the important point here is that there is no pleaded allegation, either by way of defence by Affan, or as founding Affan's counterclaim that Affan was excluded, or that the taking over by BAM of the works was responsible for Affan's failure to perform its subcontract, or that it caused Affan any loss. So, just as Mr. Doyle gave no evidence that Affan's personnel were not prevented from entering the site facilities, there was no evidence even from Dr. Affan that they were excluded. So Affan's submission that there was no right for BAM to take over the works, we say makes no difference at all to this case. And the submissions are also inconsistent with the Supreme Court decision I quoted earlier. What the evidence does establish is the breaches of contract that are set out in our table. Well, I think in the discussion of the point that you put to me, we covered a little further ground. But I do say that there is no claim for any variation that had been established, and there's no evidence of BAM withholding payment to which they were entitled either under the letter of intent or under the subcontract. Furthermore, of course, there was some 12.5 million AED paid for historical costs under the addendum. And there has been no attempt by Affan, either in the pleadings or in their evidence, to justify their stoppages or their breach of the contract. All that has been said is by Mr. Hussain that, well, they were in the position of an unpaid subcontractor who was entitled to stop work. But there's no evidence that they had any such justification, and there's no evidence that they stopped work on that basis. Affan's case on this is that BAM had no right to step in under the addendum. That's a new case, as I say, and the costs that BAM was obliged to meet were not losses caused by the breaches, but of course they were on the basis of the case that I have relied on, and the principle which I say underlines that. Rather, the proof of what I say about the takeover lies in the fact that BAM's taking over the works under the powers in the addendum occurred entirely without demur from Affan or disagreement. Indeed, the letter of the 23rd of June itself provoked no protest that it was unlawful, nor did the subsequent conduct of the contract by BAM provoke any protest from Affan. It's idle perhaps to speculate, but it may be that this all came as something of a relief to Affan. There are, Your Honour, a clutch of documents in the bundle that we didn't look at during the hearing, but they're significant in this regard, and they speak for themselves. And I'll tell you about the most significant and invite you to read them for yourself. The first is a letter of the 28th of June from Affan, signed by Mr. Affan to Mr. David Fagan. Mr. Fagan worked for Miras, the employer's representative, and he says, he starts the letter, "Was nice talking to you yesterday. I very much welcome your acceptance to mediate between BAM..."
Do you have a reference for that, please?
2553. I'm so sorry if I didn't give it to you.
2553.
2553.
Yeah.
28th of June 2019. So just 5 days after the 23rd of June letter. And it talks about the dispute between BAM and Affan being purely commercial. It says there we're owed a lot of money as per the terms of our contractual agreements. And it says BAM so far avoided making the payment, citing insufficient substantiations. Your mediation would be greatly appreciated. The inference that I draw from that is that they're talking only about money that was, they say, was due under the addendum. And there was an argument, or substantial argument, about whether the claim had been substantiated. I'll come to that a little more. There is, of course, no claim in respect of withholding money under the addendum mounted by Affan. And then what's said by Mr. Affan to Mr. Fagan is, with this financial pressure, Affan would not be able to complete the facade work. I hereby request you to ask BAM to operate our entire facilities until the completion of the Museum of the Future project. This means, and then the first bullet point, paying a monthly lump sum, 4 million AED, related to running cost and production costs, utilities, maintenance, insurance, depreciation of facilities and equipment, approximately 2 million a month salary of staff until the completion of the project, approximately 2 million a month. This value can be determined by a third-party consultant. And so on. So what it appears that he's saying is, please mediate. BAM should take over the running of the project. And there is going to be needed a total of 4 million, made up of these two 2 million sums, to do that, because we can't pay it. And it appears that he's talking about money under the addendum, which is unsubstantiated. It contemplates BAM taking over the completion of the subcontract. The next letter is 2556.
Dr. Affan wasn't cross-examined on this, was he?
No. These were letters which post-date the 23rd of June. It may now, the way the case has developed, have been better if he'd been cross-examined on this letter and some of these letters, but they were after the sort of relevant dates that we were looking at, and there was an awful lot of material that obviously we didn't go to. But
yes, I mean, it's a bit difficult for me to make factual findings based on these letters, not having heard Dr. Affan on them, particularly if you're seeking to draw inferences rather than just relying on their express terms.
Well, I'm perfectly content to accept that. I rely on their express terms. The point that I make is that the idea that this takeover was against the contract or was against Affan's wishes is not borne out by the subsequent reaction of Affan to what happened. And I also put that in the context of my argument that there is no pleaded allegation or claim of loss arising from or out of the takeover. So that the proposition now put in submission only by Affan that the takeover was somehow unlawful is not borne out by the documents any more than it's supported by a pleaded case, and is inconsistent with the case they were putting before Sir Peter Gross. The next document is 2556. And is merely illustrative of the fact that Affan was putting forward payment applications after the takeover. This is a payment application for August 2019. And they were doing it in the context of the takeover, and were effectively saying, entirely consistent with the evidence of Mr. Doyle on the document he was cross-examined on at 2722, that they were still being treated as the subcontractor entitled to payments for the work. But it says at 2558, and this is uncontroversial, it is to be noted that all the panels are produced, inspected, delivered and installed by BAM without coordination with the Affan management. Therefore, Affan, they say, have serious concern on the quality standards of the produced panels under BAM's supervision. Affan will not be held responsible or liable at any stage for the panels forcefully produced by BAM using Affan facility. So that's an acknowledgement by Affan that BAM is doing the work on producing panels. Then at 2573, this is a letter from BAM to Affan, dealing at this stage, it's the 15th of September 2019, with the claim that's been submitted at variation number 2, asking for changes in the design of the facade, or asking for a variation in respect of that. And that is a response by BAM saying that there is no variation, and they cite clause 21A or B of the subcontract. No such instructions, which is one of our arguments, as you know, have been issued to you. In the absence of any formal instructions, please clarify the supporting documentation, the contractual basis of your purported claims. And then at the end of the letter, they conclude there's no contractual basis for BAM to value or determine any entitlement under clauses 16 and 21. Then 2587, which is a letter dated the 27th of November 2018, deals with a further breach about the control mechanisms on the gantry cranes. 2590 is an interesting internal letter. It's from Mr. Bachar Chehabi, dated the 8th of December 2018. And it raises the point that you raised with Dr. Affan and with Mr. Hussain on a number of occasions, that it was Affan who had the leverage. And Mr. Chehabi writes to Mr. Affan, to Dr. Affan, BAM considering themselves in a false position and trying to treat Affan as a slave just because they're paying money, forgetting the fact that this financial difficulties are due to huge changes in design with a consequence of an important wastage of materials. We should not forget that we are a specialized contractor and it's very difficult to replace us. It will cost a lot of money and time to BAM to find another available contractor to restart everything from scratch. I believe with this card in our hand, we can have a better deal with them. All of Affan's employees will support you as usual. At 2591, there's a letter dated the 15th of December 2019, which deals with the allegations of facade design changes. That's a letter from BAM to Affan, and I needn't take you to the detail, but I do invite you to read it. And at 2597, the final letter in this batch, is a letter from Affan to BAM saying, "Dear Maged," says to BAM, "as mentioned in our previous letters, Affan is trying to regain full control over Affan's facility since 17th of December 2019. In light of the recent court decision to attach the Altea facility from a third party," I needn't worry about that. But what they say effectively in that letter is they're trying to regain full control and they want to continue with the production of the panels. I cite those letters as undermining the suggestion that this was an uncontractual takeover, that BAM was not entitled under the addendum to effect or on the basis of breach of contract by Affan to effect. In relation to regaining full control over the facility, there is a passage in that letter where he says, "Our DIP facility," that's the Dubai Investment Park, "which we're actually using exclusively for the MOTF, Ministry of Museum of the Future production, will remain available for the completion of both the design and fabrication of the panels relating to the MOTF project, as utilised by BAM exclusively since the signing of the addendum in December 2018. That's interesting because it suggests that BAM was in place in December 18 on the signing of the addendum, some 6 months before the letter of the 23rd of June, where BAM effectively did take over as a result of the breaches of contract. In respect of all of this, the UAE authorities cited by Affan do not assist the defendants. May I just say in passing that the reference for the certificate Mr. Doyle was cross-examined about was 2722. And the reference to the gross work done, and you'll see that the gross work done to the date of that certificate, which is 25th November 2020, was a value of 98,885,638. That was the gross work done, as Mr. Doyle explained, not by Affan, but the gross work done about the towards the contract, both by Affan and by BAM, since they had been paying under the addendum and paying the staff and everybody else. What we say about BAM's claim to damages here is that Affan's analysis fails to address that BAM was entitled to expect to be have the subcontract works completed in accordance with its terms and at the subcontract price, adjusted for variations established, but only established in accordance with the subcontract. And there's one important issue on the point that you made, which is that at paragraph 5.11 on page 13 of their closings, the defendants run a line which they raised in opening as well that it's common ground between the quantum experts that Affan has not been paid the value of the work it performed, so that BAM was entitled to suspend work. That simply wasn't true as a matter of fact. The point of law on suspension for non-payment we've covered. You queried during the hearing whether a notice was needed before there could be a suspension of work for non-performance. And in relation to that, I would draw your attention to paragraph 6.2 of our closings, dealing with Article 247 and the DCC, the Court of Cassation case 288 of 2019, which is CCL 6, which we say demonstrates that notice is required before a suspension. But the underlying facts of Mr. Hussein's submission are simply wrong. It's not the case that Affan had not been paid the value of the work it had performed. And the defendant's submission to that effect involves a misreading of the quantum joint minute number 4, which I call QJM4, because it fails to take in any account of the sums paid by BAM on Affan's behalf. The quantum experts are clear on that. At QJM4 on page 13, that's internal page 13,
Have you stopped speaking? Because I can't
no,
hear you.
I haven't stopped speaking. Sorry, I was just looking for something. It's actually internal page 14. The experts agree that the valuations set out above do not include any adjustment for costs that BAM has incurred on the first defendant's behalf in connection with the panels that were delivered and installed by the first defendant by the end of May 2019. This is addressed at section 6. And when you go to section 6, it's quite clear that what needs to be taken into account is not just the amount that was paid by BAM to Affan, and I say to Affan Building Systems Limited as well. That's column G on that page. There is no serious argument that the building systems money shouldn't be included. That comes to AED 54,357,214. But there's also the valuation of the work done at BQ rates, which is 75,699,687. And by Mr. Kenyon and Mr. Affan, 73,977. And that's on the basis of panels delivered to the end of May 2019. But the point that I make is that if you go to section 6, paragraph 6.1.1, what is said by the experts as an agreement is, as per QJM1 and QJM2, the quantum experts provide a valuation of costs incurred by BAM, which are in addition to amounts paid by BAM to the first defendant. The costs incurred by BAM procuring materials directly on the first defendant's behalf are set out in section 2 above. The amounts are split between two periods. First, pre-June 2019, and secondly, post-June 2019. And on page 24 of QJM4, Mr. Kenyon values the amounts paid by BAM on the first defendant's behalf pre the 1st of June 2019 at 71,089,507. And that's in column E of that page. And that's for production costs, running costs, finance and miscellaneous costs. They don't include the historical costs because those have already been taken into account as the money paid by BAM to Affan. And Mr. Kenyon's valuation of the amounts paid by BAM on the first defendant's behalf before the 1st of June is 65,125,068. And that's excluding the business systems money. Mr. Atherton's valuation is 76,359,646. And those are amounts which are payable by Affan to BAM as their costs met by BAM, and they're set off under clause C6 anyway. And this is all agreed in QJM1. So that the total amounts paid have to have added to them the amounts that have been spent by BAM on Affan's behalf. And so the total is 119 million odd against a valuation of work at that stage, which is as high as 76 million odd. So that on the view that is most favourable to Affan at the 1st of June, Affan has in fact had 43 million AED more from BAM and the highest valuation of its work to date. I appreciate that's quite a complicated set of figures to go through.
Well, I'll pick it up from the transcript.
I think when you do pick it up from the transcript, you will see that the submission that Affan has not been paid the value of the work it has done is simply wrong when you take into account the amounts that BAM has spent on Affan's behalf that were payable by Affan under the addendum by the 1st of June. And so that there is plainly, it was a greater figure on the document that Mr. Doyle was cross-examined on, but there's plainly as a minimum, a 43 million AED overpayment in respect of the work that's been done. I set out the quantum of BAM's claim at paragraph 44 to 49 of our closings, and substituting, you'll remember there's a figure of 911,000 odd for the emission of the sandblasted etchings, and there's a compromise figure of 500,000 that's agreed as a compromise figure between the 911 and naught. And the agreed figure on option 1, therefore, is 104,576,663. I say on option 1 because you'll remember that option 1 is the figure which includes the actual spend by BAM after payment procurements requests had stopped being issued in June. And Mr. Atherton didn't seriously argue for the omission of those payments because they were actually made. And that was option 2. The payment procurement requests were simply not issued by Affan, and that didn't stop the payments being made. So that the amount adjusted of BAM's claim is 104,576,663. And that's made up of the 233,847,011 which is line C on Schedule 2 of QGM4. That's the total of the works, less the recovery, which is 21,875,000. That is the performance guarantees and the advance payment bond, less the adjusted subcontract price, which is 107,395,348. And that nets out at the figure I've just given you of 104.5 million. As far as interest is concerned, the defendants make a submission that interest should now be awarded at 9%. We don't quite understand that. The authority put forward suggests 5%, and we're given to understand that the practice of the court is to award interest at 5%, but we're in the court's hands on that. Or if I may turn to the claim by BAM against Dr. Affan personally, I'll deal with the three allegations of dishonesty separately, but before I do, I should say this. We do not accept that these were not proper allegations to make, nor do we accept that they weren't put adequately in cross-examination. They may not have been put as a criminal prosecutor might have put them before a jury, and they may have been made more politely than such a prosecutor might have put them. But Dr. Affan is an intelligent man with a PhD from Cambridge. He can have been in no doubt at any stage that what I was putting to him was an allegation of dishonesty and untruthfulness in relation to each of these three allegations. In particular, and I'm adopting the words of Brown and Dunn cited by my learned friend, in answer to my detailed cross-examination, Dr. Affan had ample opportunity of explaining any contradictions or alleged problems with his evidence. Furthermore, applying Catgold and Colonia, also cited by the defendants in paragraph 8.6, I made it clear to Dr. Affan where BAM does not accept that he was telling the truth and where the dishonest knowledge or recklessness was to be found. And I add to that, this was particularly so given that the case was pleaded in detail in fraud in respect of each of these allegations. Allegation 1, misappropriation of project costs, which are the historical costs, paragraphs 59 to 71 of the particulars of claim. Allegation 2, which was claiming costs unrelated to the project, paragraph 72 to 80 of the particulars of claim. Allegation 3, which was the security checks at 56.3 and 59 of the particulars of claim, and then 81 to 87 of the particulars of claim. Furthermore, the pleadings in the particulars of claim were no surprise to Dr. Affan because they came against the background of the previous determination by Sir Peter Gross of the jurisdictional challenge that Dr. Affan mounted. And I draw attention to the findings of Sir Peter at pages 572 to 581. The allegations were put in detail in paragraph 21 of his judgment, page 572, and Dr. Affan suggested answers in paragraphs 22 to 24. Furthermore, the allegations have been put in great detail in Mr. Doyle's witness statements, respect of historical costs at paragraphs 55 to 77 on pages 626 to 632, claiming reimbursement of unrelated costs, paragraphs 78 to 88 at 632 to 635, and dishonored security checks at paragraphs 94 to 99 on 636 to 637. Dr. Affan had responded to each of the dishonesty allegations in his second witness statement, dated the 25th of August 22, in preparation for the final hearing of the jurisdictional challenge, dealing with precisely the allegations that were then and are now made. Although his other witness statements were, to say the least, exiguous in relation to most matters in dispute in the case. He'd set out his responses in some detail to the dishonesty allegations, and the dishonesty allegations have not changed in form since they were first made in 2022. What had changed was the detail of the evidence which was put to him, in which he had a full chance to explain in cross-examination. Mr. Hussain repeatedly made it clear in Mr. Affan's presence that these were serious allegations of dishonesty, and repeatedly invited BAM to withdraw them, which BAM made clear through me that it was not going to do. Dr. Affan was quite clear of the dishonesty allegations, and it was clear to him from the cross-examination what was being challenged. I set out in our closings a submission that the allegations of dishonesty have to be seen in the context of background. And that, we say, is background dishonesty in the general presentation of Affan's case. And Affan's closings do not address any of these issues at all. So we don't yet know if the defendants maintain that it's permissible for you to consider the allegations of specific dishonesty in the context of Dr. Affan's dishonesty in relation to the case as a whole. We say it is, and we accept entirely that Your Honour will have taken a view of the honesty and probity of Dr. Affan as a witness, and I don't seek to invite you to a particular view. That's a matter for you, but you'll see you'll have no difficulty in divining our position on that from the submissions that we make. We rely on the original presentation of the variation case, which was
sorry,
based
I just
on
want to, I'm sorry to interrupt my learned friend. He's talked about the pleaded allegation of dishonesty for which a claim in damages is made, and I will make submissions on that, which will be no surprise to you. But he seems to be making a further point now that the witness perjured himself and was dishonest in his evidence. Is that what he's seriously saying? If so, I would like that to be either put clearly or withdrawn.
Well, it's not going to be withdrawn, and I'm going to make it good. And we say it's quite clear where he's been untruthful and where he's not been untruthful. And you'll have to answer the submissions when your turn comes.
I think this was canvassed to an extent in the closing submissions.
Yes.
That there was a general, there is an allegation in the closing submission that there was a general dishonesty in the way that the case was put, and you did submit in the closing submissions that I should take that into account.
Your Honour, yes, that's exactly the point I was just putting. And what I then said was, of course, we don't know whether Mr. Hussain is going to accept that, because there was a
well, I suspect he won't.
Closing submissions, and I'm now seeking to make that submission good, not by simply repeating it, but by making some points upon it, and by addressing points that have been made by Mr. Hussain in his closing submissions. And you will appreciate that we rely on the fact of a change of case by Dr. Affan, and we say that is of itself redolent of untruthfulness. The original case was presented on the basis of variation based on the 13th of March meeting. Then there was a change of case to tab 15, and you'll remember that tab 15 was said to be attached to tab 14. You'll remember the discussion about that. And when we said that we had discovered that it could not be so, you said that was a very serious allegation to make, and so it was, and it turned out to be true. They've then now put the case on the basis of tab 14, which I call the red line model in our closings, and we say that there was basically untruthfulness in relation to that. we also say that the whole story, that there was the creation of a Katia model, which was originally the story and evidence between the 2nd and 7th of March, was wildly unlikely, and it was certainly an impossibility between the 6th and the 7th of March, when they now say that tab 15 was produced on the 6th of March, and they accepted at trial that there was a Katia model produced on the 7th of March.
Yeah, I've been looking at the Katia model issue, and one thing I think that has not been picked up is the use of the word surface in Mr. Haslam's witness statement. So, as I understand it, Katia can produce a fully working model of a building, and you can call off the quantities, and it can generate shop drawings, whereas Rhino it essentially gives you a surface model of a building. And I was wondering whether the use of the word by Mr. Haslam as surface really meant that it may have been the Katia software that was used, but initially, but it was not used to the full extent. It was used rather like Rhino software, just to give a rendering, rather than a fully articulated Katia model from which you can generate shop drawings.
My understanding is that the surface is produced on the Katia model because that's how you produce the smooth surface, which was what was wanted by the engineering team.
Yeah, that's not an answer to my question, I think, because you can produce a rendering of a building with a smooth surface on Rhino. The question is whether what's behind the appearance of the building that's rendered. And as I understand it, behind Rhino, there is not the same detail that there would be behind a Katia model. And I was just wondering, when Mr. Haslam was using the word surface, he's effectively saying, well, Katia was just used initially to produce the sort of rendering that you could produce on Rhino.
Well, I'm not sure about that, because he said that the Katia model was used in, and I don't think I don't think anybody's been qualified except for Mr. McCabe, who wasn't asked about it, to say what the difference is between the capabilities of Katia and the capabilities of Rhino might have been.
No, but why does he use the word surface in the witness statement that you've produced?
Sorry, I think I need to look that up.
Yes, well, he uses it at least twice, I think, from recollection,
yes,
in his witness statement.
Would you give me a moment to?
And he is a quantity surveyor, so call-offs would be his thing, really.
Certainly, yes. But I now have Mr. Haslam's statement up.
Let me get it up too. I mean, all I'm saying is that there may be an explanation which is not consistent with dishonesty when one's dealing with the Katia model. I mean, Mr. Hussain says it's a red herring in any event.
What he says at 22, though, is well, perhaps I can go back to 21.
So we are in we're in file 27, aren't we? Attachments. No, we're not. It's 28, is it?
It's in the post-hearing memorials, which I think is 24.
It's 24. Thank you very much. Post-hearing memorials.
24. Post-hearing memorials. Claimant. First witness statement.
Yes. Got it.
And if you go to 21 on page 5. A further competitive advantage was the first defendant's ability to model projects using the CATIA software system. This is because CATIA is a powerful software tool which allows for superior modeling. I recall that the intended use of CATIA initially caused difficulties in 2015 because BHE, the engineer, advised that it didn't work in CATIA, BHE didn't work in CATIA, nor did it even have the software, and as such required models and drawings in 2D. D1 was adamant in 2015 that a project of this nature and complexity could not be modelled without using CATIA software. It was stated post-award that each panel should not only be drawn in 3D, but also approved in 3D, something BHE was not initially willing to accept. Accordingly, D1 began preparing surface models using CATIA in 2015, as shown by the attached CATIA file dated 14
that's the whole point. That's the whole point, isn't it? That when he's using the word accordingly and surface models, what he's talking about is something which is not a if you like, full CATIA. At 24, I recall that the initial CATIA surface model was sufficiently far advanced so as to construct the life-size 9-meter mock-up prior to tender. Yeah. But he's used the word surface twice there. He actually used it again in 26 as well. So he clearly understands what CATIA is capable of.
Well, at 26, you see, he says this is where I say that Mr. Dr. Affan was untruthful. He says the CATIA model developed over 2015 and 2016 was also used as a basis for D1's tender. And then he believes the models shown to me at page 916 and 917, the combined bundle, were iterations of the surface model worked by D1 in CATIA. Yes. Whilst I know it was a finished product and fully cognizant of the fact that it's designed to be developed and refined, D1 was able to estimate the number of panels to be included in its tender based on the typical, so I'm going to have to go down, size of 9 by 2.2 meters. That's to say that through the initial CATIA model, I understand your point that this is the initial CATIA model. My point, though, is that certainly as regards 916, is that Mr. Dr. Affan's clearance was that 916 was untruthful in saying that we have developed a CATIA model and panelization and proposed panelization. He first said that was because he wanted to, as you put it, pick himself up to the architect, but it was clearly there, and it was clearly not true. I mean, it could be. It could be. His evidence was clearly not true.
Well, I mean, it depends, doesn't it? It depends what you mean by a CATIA model. I mean, if you mean a fully functional CATIA model, then clearly there was no fully functional CATIA model. On the other hand, if you mean a surface rendering, then a surface rendering was produced on some software.
Yes, I do appreciate now what you're saying, and indeed that is consistent with the tender proposals. When I think in the method statement, and you'll be able to find the detail, they say after tender we will get down to producing, I think over a couple of months, the fully fledged CATIA model. So the CATIA model obviously needs some development. The point that the evidence about the CATIA model is getting at is that there was a CATIA model in place before the tender proposals, and that when as a marketing ploy, or pull, as a USP, Affan were saying, we have produced a CATIA model with proposed panelization at page 916. They were telling the truth, and Mr. Haslam, who prepared this and was responsible for this document, was telling the truth, and Dr. Affan was not telling the truth when he said that was makeup.
Well, he was not telling the truth if depending on how one understands what CATIA model is. I mean, there was not a fully functional CATIA model. I'm just wondering how firm this ground is for me to infer dishonesty. That's all.
Well,
I mean, you may have other points.
What I can say is that it's got to be taken in context, and if you're with me on other points, you may well take a different view. If you were inclined to think that there was an excuse for that bit of his evidence, I say that you'd have to take it in context and look at the whole of his evidence.
Yes, I mean, it's not a matter of thinking there was an excuse. It's a matter of me being persuaded that the only sensible inference from the evidence is that Dr. Affan was being dishonest. But if there is another plausible explanation, then it's very difficult to make the inference. That's all I'm saying.
I understand that, but I invite you to look at the whole of his evidence about what was said at 916 and his reasoning for it, and his suggestion that there was, not suggestion, his evidence to the effect that there was no CATIA model at all until the 7th of March. And that is the context for his saying that 916 was simply wrong and untrue, and put in there as a slip of the tongue. And I invite you to the inference, and it may be that you need other evidence to support it, that was an untrue piece of evidence.
Yeah, well, I have your submission on it.
I think the next point here is that the defendants suggest and make there's a brave submission, paragraph 42 of Affan's closings in paragraph 17.3, that there is no CATIA model. They say there is no CATIA model now, which is an extraordinary submission to make. And this all has to be seen in the light of the fact that Mr. Hussain assured the court on the 29th of October that there was such a model, presumably on instructions that he's never corrected, and he said that would be available for inspection. We say that the evidence of Mr. Haslam, at which we've just looked, and I entirely take the point about the distinction between undeveloped / surface model and fully developed model from which you can draw off working models of components and so forth. That is a legitimate distinction, but it doesn't mean that there was no CATIA model before the final CATIA model was produced. We say the evidence of Mr. Haslam shows there was a CATIA model. And if you look at exhibit PH1-1 and the evidence of Mr. Michele Florian, his original joint report with Marina Kinderland, and the evidence given orally on the 12th of December, which was unchallenged by Mr. Hussain on this or any other point, and his evidence in his subsequent witness statement explaining PH1-1, which has now been downloaded.
Yes, I can't open that, I'm afraid.
It's been added to the bundle at EB28, and I'm not sure that in the volume that in the
okay, let me have a look at.
Well, in the USB you've been sent, I understand that that's not there. but that it is there in the electronic bundle that you've been sent. And if it's
So
not there,
28. Okay.
yes, it's EB28.
I've got the second expert report of Michele Florian or
Yes.
Michelle.
Yes.
But you were referring to the exhibit to Mr. Haslam's witness statement PH1-1 in tab 24.
Yes.
And I can't open PH1.
That's the one that's not openable.
Yes,
And
it
the
says
whole
Museum of
point of-
Future 141205.
Yes.
It claims to be an Adobe Acrobat document, but my Adobe Acrobat can't open it.
No. The whole point of Mr. Michele Florian's second witness statement
Yes.
is that he has been able to open it, and he's produced a copy of what it shows, and
Okay.
he's drawn his conclusions as to what it shows.
Okay, let me see. Sorry, let me go then to
Yes.
tab 28. I've got, so where do I see within that report then a copy of what it shows?
Can you forgive me because I'm going to have to go to tab 28 now.
I don't think there's any, I don't think it does. That's the problem. I've provided an enlarged screenshot. Oh, there it is.
I think you
Okay.
have.
Below showing, it doesn't come up. Paragraph 8, he said,
Yeah.
I provide an enlarged screenshot.
You haven't got that.
But where is it?
I'm going to have trouble getting that up at the moment because of the format in which I've got it. But
I don't, it doesn't appear to be here at all. It's not within my tab 28 as an exhibit to.
can I
This
simply
report.
invite DNA to make sure that you have that?
Yes, please.
Sent as quickly as possible.
Apologies
whether it will arrive before the end of today's hearings.
apologies for interrupting, Lord Marks and Justice Black. Just to confirm, the enlarged screenshot of the file path does appear, it's on screen at the moment, it does appear below paragraph 8. It's the file path, which is from PH 1.1. It's being selected as we speak. Justice Black, just to confirm, you can see that.
I can see the path. I'm just, what I can't see is what PH11 is.
No one has seen that. No one has ever seen that. Mr. Florian confirmed.
The file path is what has been opened. The full file path, what's been opened.
That's why I just wanted to confirm. So just to be clear for the record.
So nobody can see what it is.
You can't see any drawings on it or anything of that sort.
Okay.
What you can see is that what Mr. McCain says, what Mr. Florian says about the conclusions that you can draw from the file path. And that's what his statement is about. So
okay, so we can't
I'm
see.
Still not on vision, so I can't see what's on the screen. But
okay, well, in that case, I understand. So we can't. So nobody. I think Mr. Hussain said nobody has seen the document which that refers to. Is that right?
They've seen the file path which Mr. McKelly Florian has been able to, and nothing more.
Yes. Okay.
And he's been able to explain what that is.
Just to be clear, Justice Black, apologies, Lord Mark. It's the file path, because I know you can't see, Lord Marks, the file path on screen, but the file path under paragraph 8 in his witness statement, second expert report, details that obviously the position where the file originated from, and obviously it's stating 2015. Affan Projects 2015 Inquiry Museum of the Future. That's where the CATIA, that's where the file came from.
Okay, but so PH11, which I couldn't open, does not contain a drawing, a document, or a render. Is that right?
So the problem is we can't access that file because we don't have access to P double colon / Affan projects. If in theory, if that file was to be placed on a computer that could access the file path, then the file would pop open. But because the file was shared, absent the access to the original file, all we can see is where the file originated from. So the file path itself, which is on screen. So that's why we can't open it, because it's calling back to that path, but we don't have access to that path because it's within Dr. Affan's computer system.
Okay, so then in fact this exhibit to Mr. Haslam's witness statement doesn't show anything. Is that right? I mean,
well it doesn't show as any drawings, but the point that Mr. Florian is making is that this suffers from the same problem as the files that the experts were shown when they conducted the inspection, which was that the link to the master model had been was absent, and without the link back to the master model, you cannot get from PH1-1 to the master model to see any drawings at all.
Okay, but you, the odd thing is Mr. Haslam's your witness, and you put in a witness statement then so how could you have put in PH11 at all if you didn't have access to it?
Because PH11, from what he knew from the file path, what Mr. Haslam knew was that was a CAT document. And he understood, and I'm saying we understood, that that Affan's case was that there was nothing done in Katia until the 7th of March 2017.
I know all of that. I'm just trying to work out what PH11 was meant to be.
It demonstrates that there was Katia in use in 2015 in connection with the Museum of the Future project, an Affan project created by Affan and linking back to a master model, a Katia master model.
But can we just get up?
If Therese moves up a bit, because the screenshot above paragraph 8 is equally relevant for this. So if the document controller could just move to the page above.
I've got it in front of me anyway. Yes, okay. I'm not so. Regarding it suffers from the same problem filed in, namely that the underlying master is not available. So that PH1 says an unavailable document as now you see I can't access this screen, so I can't access this screenshot.
And apologies, just to be clear, which screenshot is the one above paragraph 7? If we keep scrolling up a bit.
Yes, I can't see that. So that's what PH11 is it?
That's effectively what happens when you right click on the file in basic terms to see the properties of the document. So it shows you what the properties of that document are. Effectively, it's on screen at the moment. Can you see that the import report?
Yes, I can see. I've got it in front of me from the bundle as well.
Yes. So just from if you were just to use an example, if you were to move a Word document onto your desktop and right click on it and go to properties in a Windows.
I know that. So let me just go to electronic. Where's Haslam in the electronic bundle? Remind me again. He's in.
Haslam is in 24.
He's in 24.
Claimant.
24 claimants. Okay. First witness statement, Haslam, PH11. Okay, so there's a document, and if I click on properties, I don't see that. I see it. I see the Adobe properties of it.
Yes, which would make sense given that we've moved it onto a USB pen. But when the expert opened the document, he was able to pull from it the originating containing folder.
But I can't open this document at all.
Someone with the requisite software can do that.
They only get okay.
I think it's important that you should. I think it's important, Your Honour, that you should have that document sent to you in an understandable form.
Sorry, Your Honour, this is not a document, as Mr. Mackenzie said, that was shared in the review. This is a document that was just simply sent with Mr. Haslam's statement. And the claimant is using it to make quite serious allegations of dishonesty when it can't even open the document.
I'd be very grateful if Mr. Hussain would wait his turn on this, because we're short of time and this is a complicated issue.
Well, I have to say that that Mr. Hussain is only speaking what's in the back of my mind.
Well, I
if this is a foundation for an allegation of dishonesty, then I need to understand. I need to see the document.
Well, I'm suggesting that you should see everything we've seen, because it makes quite clear that Mr. Haslam is right, that Katya was in use in 2015, that there was a master model for which the link is unavailable now, and that was available in 2015 prior to the tender, well prior to the tender, and that was being used, and it was being used to make the
okay, but I can't currently. Yeah, currently I can't see what is set out at paragraph 6 of the second expert report of Mr. Florian.
Yes, but Your Honour, it's important that you show that Mr. Mackenzie will organise that.
Okay, all right. Well,
Mr. Mackenzie, that's not a problem of given time, is it?
Well, I just want to make sure everyone's on the same page. I appreciate timing, but this is a very important issue. So, to be clear, the second expert report is effectively the evidence that we're submitting, which the other side has not presented any evidence to the contrary to contradict it. That effectively,
well, let's not get into submissions at the moment. It's just I'm just interested in the provenance of the document.
I appreciate that, Justice Black, but the evidence is that this file did exist in 2015. The fact that we can't open it, only someone with CATIA can actually even look at the properties of the document.
So just cutting through, it is what is under paragraph 6, what you see when you use CATIA software.
Yes, exactly, Justice Black. So effectively, the content of the document is somewhat irrelevant. It would be great to see it, but we can't because we don't have access to the original file path. Only Dr. Affan does, potentially.
So Mr. Florian, yeah, I understand all that. So Mr. Florian used CATIA software to generate what is the screenshot under paragraph 6 of his second report. Is that right?
Not so much generate, but effectively pull that data from the file, yes.
Okay. Then I think I understand the position.
Thank you, Justice Black.
Your Honour, we've, I think, dealt with that as far as we can before you see the
I think we have. Just in terms of timing.
I mentioned. Sorry. Yes.
Yes, Lord Mark. Just in terms of timing, do we have a live transcriber, or are we all AI? If we're all AI, we can carry on. If there is somebody who is actually typing away at Terrace to correct the feed, then they may need a slight break. Could somebody just let us know whether a break's needed or not? If not, I'm happy to blast on if you are, Lord Marks.
Well, I'm happy up to a point. If I could just get my tech people to see if they can get me vision, that would be helpful. And they might be
helpful. I'd love very much to see you. Should we just take 10 minutes? If we're on English time, should we take a break until 11 o'clock English time, which will be 3 o'clock Dubai time?
Your thank you.
Okay, let's take 10 minutes. I can now see you.
I can see you, and maybe even I'll be able to see the documents that are put up. Somebody's going to come and check that I maintain vision every 10 minutes over the next little while. So if you see somebody coming in, that's what it is.
Good. How much longer do you need? We ran then just over an hour and a half, I think. We ran just an hour and 3/4, didn't we? Just then.
I think I started about 10 quarter past 9.
Quarter past.
And then
Okay.
something like that, and then we start at 10 to. But in any event, I hope, speed up now, and I hope that I will finish within an hour.
Good. Okay.
Wrong thing.
Good. Okay. Well, as I say, I'm fairly relaxed about.
Wrong. That's very helpful.
Mr. Hussain, sorry, Mr.
You're-
Hussain, I think what.
I'm a bit concerned about finishing an hour. That's way above the 2 hours allotted.
Well, I can give you the same time if you want.
I mean, your hands, you're on.
Well, as I said, I was about to say, I'm fairly relaxed since we've got an early start, and if you have the time available and wish to use it, I'm quite relaxed about that.
Of course, Mr. Hussain.
Is that okay, Mr. Hussain?
I mean, your hands are on. I really have nothing more I can say.
All right. Well, as I say, I'm very happy to give you similar latitude. So, Lord Marks.
So moving on, we talked about Mr. Haslam very briefly. In the defendant's closings, they say that it now transpires that Mr. Haslam was contacted by the claimant at an unknown date and told to watch the YouTube transmission of the trial on the 28th of October. Well, we say that's misleading and gives a false impression. Mr. Haslam's statement at paragraph 9 is that on the 28th of October he was contacted by Mr. Craig Foster, who's an ex-employee of BAM, who informed him that the proceedings were taking place and that the hearing was available to be viewed on YouTube. And thereafter he viewed the hearing on YouTube, and he wasn't challenged in any particular on that by Mr. Hussain, far from being told by the claimant. Well, I'll move on. The Katia inspection is a matter that we place considerable reliance on. The only conclusion from the evidence about the Katia inspection in the joint report is that the original Katia model had been withheld and that new and frankly useless files were created from it on the 4th of November 24, 6 days just after we were assured by Mr. Hassan that the model existed and was available for inspection. And yet they now say there was no Katia model or is no Katia model at all. That whole account is only consistent with an attempt to hide the development of the Katia model and the origin of the Katia model. It would have shown, we say, you necessarily have to infer that the Katia model was created in its initial form, certainly in 2015, well before the tender proposals, and it would have shown the development thereafter.
Where do I see the evidence that new files were created on the 4th of November?
You need to look at the joint model relating to the joint report of Mr. McKinley Florian and Ms. Kinderlan following that inspection.
Okay, I've got that.
Yes, that's the one. If you just read that report, I'm anxious to save time where we can.
Well, just show me what you particularly rely on to say that files were created on the 4th.
We run through.
Yes, I want to know what section, what part of the report proves.
Yes, I'm just asking that we scribe through the report. Otherwise, I'm going to have to get it up, but I can get it up, but it'll take time.
I have it here. If you can just give me 2.1.6, I think. Is that what you're referring to?
Yes. Yes, additionally, it's both these folders were saved to the computer. We previously understood the data made available to us was all available as the project during the relevant period. No already been stored on them. The screenshot below shows a modification dated the 4th of November 24, indicating that these folders may not have originated on this computer, but were transferred from another location to which we were not given access. Had the files not been transferred from another location, we may have been able to trace the actual data creation, the date it was last modified, and the author using Windows and Explorer. And the files they were shown were all dated as the 4th of November, and there was nothing behind them. There was no reason. The experts were showing a laptop, and the evidence needs to be seen in the light of what Mr. Hussain said on the 29th of October, which was that the model was available and was on a mainframe computer that couldn't be moved. And it appears that after that, on the 29th of October, a laptop was created with, or was used, with the files transferred to it on the 4th of November. At no stage has Mr. Hussain retracted what he said on the 29th of October.
Your Honour, I'm going to not interrupt, but the transcript will show that I repeatedly said that there was no model issued prior to the 7th of March, and the inspection was to show any models issued prior to the 7th of March. I'm not sure why this.
I'm sorry.
Wrong.
Well, Mr. Hussain, let's not all talk at once. So, Mr. Hussain, let's deal with it one at a time, and I'll take your submissions. Let me get Lord Mark's submissions on board first of all, so then I can understand your submissions.
My submission is soundly based on what Mr. Hussain told you on the 29th of October, that the CATIA model was available for inspection, was on a computer that couldn't be moved, and that the defendants were happy for the experts, I think they said the claimant, their experts and their representatives, to inspect that model, and that was what was offered. When the experts got to the inspection on, I think, the 11th of November, they were shown this laptop. They weren't shown a large computer. They were shown the laptop. They were shown they were told the model was unavailable or inaccessible. And the laptop they were shown, which was all they were told was available, was the laptop, including the files that were dealt with and explained in that joint report as having been modified on the 4th of November, 6 days after Mr. Hussain said it was all available and would be shown. It's a very serious position, this. We were told there would be a full inspection of a model that was available, and what happened was that we were shown a number of jumbled files with no development history, with no discernible interrelationship from which the linkage to the main CATIA model had been cut. And all that was available was this jumble of files, all of which showed modification, which effectively means creation because there's nothing before them, on the 4th of November. 6 days after the 29th of October promise. So it's got nothing to do with what happened on the 7th of March 2017. It has everything to do with what happened on the 29th of October and the 4th of November 24, so that the inspection was completely fruitless. You invited me correctly to ask Dr. Affan only whether he gave instructions that these files should be recreated. That was on the 12th of December hearing. I asked him that. He said no, he gave no such instructions. I invite you to infer that that was untrue, because the only person with any reason for changing that was Dr. Affan. And the files the experts were shown were entirely unhelpful. And I invite you to infer that that was deliberate.
One way to test dishonesty is actually to ask oneself, why would one do this?
Exactly.
And why would what in your inference would the defendants gain from doing this?
Because the defendants had mounted a case that there was no CATIA file created before the tender proposals produced in January 2017, and that the first CATIA model was produced on the 7th of March 2017, and that if the CATIA model had been shown to the experts in its unadulterated form, it would have demonstrated that that was not true. That there was a development of a CATIA model from 2015. Your Honour may well be right, probably is right, that the original CATIA model was a surface model that was used for the mock-ups, which was exactly as Mr. Haslam said, and that it was later developed, which was exactly what the tender proposal said would happen.
Yes. So where does all that take me?
Where it takes you is that there was an attempt on the 4th of November to hide this information from the forthcoming inspection, because that information would have shown that an important plank, put it no higher, of the defendant's case was baseless.
Yes, let's assume your inferences are correct, and from 2015 onwards, CATIA had been used to produce a model, which was later developed.
Yes.
Where does that take me?
That takes you to the fact that the whole of the evidence on the variation, which is that there was an instruction to change the panelization given on the 2nd of March of 2017, is false. Because the development history of the CATIA model would have shown working on the panelization from well before that date.
But it's not in dispute, is it, that even within the tender, the defendants produced a version of panelization. I mean, the issue before me is a change to the panelization.
That's certainly right, but the development of the model would have shown you exactly how the panelization developed.
Yes.
Because he said in the tender proposals, if you reject his evidence, he said, Mr. Hassan prepared the tender proposals. We have prepared, used the CATIA model and prepared the proposed panelization. That panelization was not exactly shown, but his case on the variation depends now upon your accepting that on the 2nd of March 2017, the red line model gave instructions, that's the red line model attached to tab 14, gave instructions to carry out a completely different panelization from the one that had originally been tendered for. That would have been undermined, we say, by a true history of the CATIA model and an inspection. And that was the importance of changing the CATIA model, or not revealing the CATIA model, by producing this jumble of files on the 4th of November. In spite of the assurance that it existed on the 29th of October.
So you say it goes to the core issue of variation?
Yes.
Okay, then I understand the point.
And it goes subsidiarily to the truthfulness of Dr. Affan in saying there was no CATIA model produced before the 7th of March, and the page 916 would make believe. But that's subsidiary. The main point is, as you've said, it's in the sentence, we have completed a CATIA model of the panels, see below, with proposed panelization.
Yes.
His case is that was untrue, and that would have been exposed by a proper inspection of the model that Mr. Hussain said was available. Or if I can move on to historical costs.
Yes.
The allegation that was put and the way it's pursued was that Dr. Affan plainly knew that the money paid over for historical costs was to be used for meeting the costs that were listed by Dr. Affan. I didn't put it to him on the basis that Canoon and the others weren't paid, or only paid a fraction of what was owed, because that was uncontroversial, as we understood from the defence and the witness statement. It was accepted that there were no payments to Canoon beyond a trivial amount. Dr. Affan's defence was that Affan had no obligation to use the money for paying the listed costs when it was sought. And added for that, there was a general assertion that if BAM had paid what was due to them under the addendum, which he implied was the full 15 million, we say was the maximum, the named creditors would have been paid. And what happened at the meeting on the 25th of November 2018 and the 26th of November 18 letter, and the reference for that is 4372, and it's signed by Dr. Affan, and it says, and as requested at the meeting held by AIS, that's Affan's company, office on 25 November 18, related to the substantiation of 15 million requested on account for the project costs incurred, kindly find the breakdown of the same as follows, and he then lists them. Canoon is there, Awaha is there, Transworld is there, Diab is there, Armacell is there. And it's a clear breakdown of what the 15 million is required for, and what we say, Affan was saying it would be spent on. It was plainly put to Affan, and the transcript reference is 24th of October, page 108, line 35, to 109, line 23. Dr. Affan agreed that the 15 million AED and the list of costs were, am I using putting quotes, related. And he says that if they paid the money, that was later clarified as the 15 million he said he expected under the addendum. If they paid the rest of the money, I would have no issues. And they had to pay also the cost of running the operation. They did not do that. A little later, I asked him about the summary provided on the 8th of January 2019, references 2054, written, I accept, by Ms. Thanuja, but copied to Dr. Affan, and it was said to be about the 4 million expected on the 15th of January. Kindly find below summary for the payment of 8 million expected to be released by the 15th of January 2019. And in that list, you'll see on 2054, Canoon was there. It was said that those were April to July invoices. Awaha July to September invoices, Transworld, July to November invoices. And we say that the letter of the 26th of November and that email of the 8th of January made plain representations, the first by Dr. Affan in person, the second copied to him that he knew full well about, as to the money to be provided, what it was to be used for, and that it was to be used to meet or reimburse those expenses. In respect of his assertion that he was expecting 15 million and that somehow BAM were at fault in not paying for it, and that was why it wasn't used for paying those creditors, it is entirely wrong to say that Dr. Affan had any right to expect a full 15 million to be paid. The addendum clause C1 is absolutely clear on this. There was 7 million to be paid within 7 days of the addendum, and a further sum not exceeding 8 million following the conclusion of the audit of the historical costs payable by the 15th January. But the audit of the historical costs was a precursor to the payment. And I'd invite you to bear in mind that Dr. Affan negotiated this addendum personally with Mr. Doyle over a number of meetings in November and December of 2018. That was never contested. The audit was never concluded because Affan failed to provide the required substantiation. So he had no proper expectation of receiving AED 15 million. The unpaid amount of the historical costs, which were to be paid to the named creditors, has been agreed by the quantum experts, that's Canoon and the others, as 3.651 million odd. That's QJM 4 internal page 10. And that amount on its own exceeds the balance over and above the 12.539 that was paid for historical costs to 15 million. So we say it's quite clear they said that they were going to pay for those costs. They can't say it was a matter for them. That's what their answer is. Their answer at page 647 in Dr. Affan's statement, at the time of making the payment, the claimant did not indicate which historical costs had been accepted. They did not tell the first defendant that it should hold on to the money until further instruction. On that basis, the company prioritized the payments based on which costs needed to be paid first in order to keep the project operating. In the absence of instructions from the claimant, this was appropriate for the interests of the project, and under the terms of the addendum, I believe that a further 4 million was to be paid. It's entirely wrong that he needed instructions as to what the money was to be paid for. The money was to be paid for the amounts that he'd set out, and he didn't apply them to that purpose. Then at 4370, there's a further status report on substantiation, which is dated the 5th of February 2019. That's an enclosure to the document at 2152, it's just later in the bundle. And that accompanied the provisional approval of the new check. You'll remember that there was a check for 4 million followed the 7, and a further check for 1.539133. Affan says this was a surprise to him because before then he'd not known what was accepted and what was not. And we say that's entirely irrelevant because he'd known throughout what the historical costs were that he promised to pay for, as we say. The defendant's closings get involved in a long argument as to whether the Canoon bills had been paid and were to be reimbursed, and whether they were still to be paid. And Mr. Hussain is quite right that Mr. Doyle's evidence was unclear on that point. His understanding was that they had been paid, but he couldn't and didn't say he was sure on it. He thought they were reimbursable. But the defendant's submissions simply do not address the point that the historical costs were paid to Affan on the strength of a clear representation that the money was to be spent for the listed bills, not to be spent as Dr. Affan pleased, which was a point picked up by Sir Peter Gross in his judgment, which I invite you to read on. And if it wasn't right that this was the way the historical costs were to be dispersed, then what was the point when you say there was none? BAM's requiring substantiation of these specific historic costs, as BAM was doing all the way through to the 5th of February 2019 document 4370, which deals with these individual items requiring substantiation and the fact that it hadn't been provided. Well, moving on to claiming a reimbursement of costs which were unrelated to the project. In his witness statement, page 648, Dr. Affan gave evidence as follows, very clear. In the case of notice mentioned by Mr. Doyle, defendant had ordered a quantity of materials for a project it was executing at Plant Jumeirah. This project became delayed and the materials would have degraded if not used. Therefore, we used the materials procured on that project for the Museum of the Future. This means the invoices provided to substantiate the costs were not marked with the name of the project, but the amounts claimed can be double-checked against the quantities installed. Again, it's simply not right that BAM's case and the allegations of dishonesty were not put to Dr. Affan in cross-examination. I've listed in BAM's closings at 165 to 170 the points on which it was clear to Dr. Affan that his evidence was being challenged. Whether the prepreg was generic or not, as he said, it was quite clear to him that the whole story about Palm Jumeirah and generic prepreg diverted from a delayed project in Jumeirah to the museum was untrue. The Dubai Mall project, after all, is right in the centre of downtown Dubai and miles from Jumeirah, as Your Honour well knows. The account that the prepreg was specially developed for the museum, which you'll remember he gave in the letter, yet it was now supposed to be generic material diverted from Dubai Mall to the museum. Again, it's quite clear to him that that wasn't accepted. It also was quite clear to him that there was an allegation that the idea that there were no deliveries to the Dubai Mall Fashion Avenue, that everything was delivered to Affan's stores, was untrue, when the relevant invoices plainly established that the deliveries were made to the Dubai Mall Fashion Avenue. And Affan's closings even suggest, not that I didn't put these allegations, but that I was somehow at fault in not being satisfied with a perfectly clear answer. The answer given that there were no deliveries to Dubai Mall and everything was delivered to his store was plainly untrue. Furthermore, these deliveries, alleged deliveries that were made to his stores, were in fact deliveries to Dubai Mall Fashion Avenue that went back as far as August 2017, a stage when the cladding to the museum hadn't even commenced. The chronology shows this at 4397. The fabrication of the panels was recorded as having started on the 23rd of May 2018, some 9 months after the deliveries to Dubai Mall Fashion Avenue, which he was provided as substantiation of a submission or of evidence that that had been diverted to the museum. It is as plain as a pikestaff that it was untrue, and it's as plain as a pikestaff that it was put to him that it was untrue. It's pages 132 to 138 of the transcript of the 24th of October. Again, the point that he made flies in the face of the truth that he knew perfectly well that the addendum required that all payments shall be signed off by the contractor as related to the subcontract. And he knew perfectly well that the point of the substantiation was to show that the payments related to the subcontract, the payments that were sought related to the subcontract. It was put to him that he told Famija to say that she provided the substantiation in relation to materials used for other projects. That was on his instruction. And he ducked the importance of that, we say, by insisting on the generic materials point. Nowhere do the defendant's closings answer the witness evidence of Mr. Doyle on this, from page 664 to 670, even in respect of notice on which I concentrated, Mr. Doyle went wider. The alternative point raised by the defendants in their closings, which I would submit is an unattractive one, that nothing was paid out in respect of the letter of credit costs for these deliveries, is not in point. As the defendants, well, no loss was caused, point. The defendants, as was agreed, and that's the 24th of October, page 130, lines 8 to 19, provided no less than 10 volumes of alleged substantiation of these costs. Those volumes were personally handed by Mr. Doyle, by Dr. Affan to Mr. Doyle, and they took all the time listed in Mr. Doyle's witness statement to go through. That was time wasted because the substantiation was simply not there to establish that the costs were recoverable within the addendum. And in any event, all the substantiation was withdrawn on the 31st of March 2019. That's page 2211. That loss of time was caused by the breach of contract in providing full substantiation. It's claimed as losses and expenses under Articles 84 and 162 of the Commercial Companies Law. And the point that there's no loss, which is the point made by the defendants, because Mr. Doyle was salaried, is a point that would be applicable to any claim for expenditure of management time. And Your Honour will be very familiar with claims for wasted management time. And there's no answer to such a claim that the manager's time could be better used, could not be used, because the claim succeeds because the manager's time could be better used elsewhere than taken up in wasteful pursuit of issues like this one. And it's a bad job. It's a bad point that it was Mr. Doyle's job to review claims. The point taken at paragraph 1116 of their closings. Certainly it's right that he has to review claims, but not bogus ones, taking enormous amounts of wasted time. Coming next to the dishonoured security checks, Dr. Affan's answer to the allegation is that there's this 648 in his witness statement, number 2. At the time of issuing them, I had no reason to believe they'd not be honoured. First defendant was still owed money under the addendum and the subcontract on this project, and therefore, if the claimant had acted in accordance with those agreements, the account should have been in funds. It was set out in our written closings what passages we relied on in response to the bold allegations, that those allegations were not put. But,
Lord Marks, I've looked at this particular allegation. I mean, while I said I'd be fairly forgiving on time, it seems to me that you need to prioritise your best points over the next half an hour or so.
Yes, I accept that.
And we really do need to look at the issue of variation, which is, as we've said, critical to the whole thing.
Yes. Well, my short point on this is that the cross-examination established that he was effectively on these checks writing them on the basis of a hope that money might be due to Affan from BAM. He said it was an agreement, and we invite you to find that Dr. Affan did not honestly believe that if the checks were presented, they would be honoured. He was effectively recklessly proceeding on the basis of a false hope that things would turn out right in the end, that he'd be able to persuade BAM to pay an increased price on the basis of a claim variation, and that the 500 panels would be completed before the checks were presented when they'd be returned, so he'd be off the hook. That is not, we say, an honest belief that security checks were good security. It's basically a cross your fingers and hope for the best attitude, and largely based, we invite you to find on the confidence that Affan had the leverage of knowing they were irreplaceable and BAM was stuck with them because BAM was on hook to the employer. Your Honour, I'll move on to the variation. We make three main submissions. First, the alleged variation predates the subcontract. The subcontract was specific. If the work was otherwise than specified, the price was to be altered. That would have to be as provided by the subcontract. Second, that the terms had to be applied, and there was no instruction to vary the works within clause 20. The defendant's submissions do not answer the point that there was a predating. One suggested answer is that the commencement date is defined by the contract at paragraph 9 of Annex 3 on page 1451, which predates the variation. However, the commencement date is effectively defined in the contract as being for the purpose of clause 16.1, which is at 1430. And I'd invite you to look at that, please.
Yes, I have it.
Within 10 days of receipt of the contractor's written instructions to do so at such other time, and so forth, the subcontractor shall enter upon the site and commence the execution of the subcontractor's works, and shall therefore thereafter proceed with the same with due diligence and without any delay. That is the only point of the commencement date. It doesn't alter the date of the contract. It's the same commencement date as is specified in the letter of intent, clause 4, which is at 1081. The date for commencement shall be considered as 23rd February, and you're required to immediately commence all activities necessary to execute the works. The letter of intent doesn't help Affan on this issue because it provides specifically in the scope of works. It's at 1080. It is understood and agreed that the subcontractor shall fully develop the design and that any further required work shall be deemed to be included in the below named subcontract price in order to fully complete and hand over the works. So whatever happens, the subcontract price, which is 125 million, is not to be altered. And there's provision, as you know, for the letter of intent to be superseded by the contract. Clause 16 of the letter of intent. So the commencement date was specifically defined in the subcontract just as a date for commencement of the works. It cannot and does not change the date of the contract.
I mean, the critical issue for me ultimately is what is meant by fully develop the design, and whether or not the freedom that was given to Affan to produce its design was curtailed by what subsequently occurred, and if that is so, whether a variation should have been granted or not. So I mean, that's, I think, the contractual analysis.
Well, I don't accept the should have been point.
No. The question is whether or not it should have been.
Yes, I understand that, but there has to be an instruction, and I don't think Mr. Hussain or the defendants have ever argued the contrary. What they argued is that there was an instruction, and they've argued that in three completely different ways. The first way they say is that there was an instruction at the meeting of the 13th of March. That's the pleading. Then they came on to tab 15. That was in the opening. That's tab 15 of the opening bundles provided by Mr. Hussain. And then when that didn't work because tab 15 wasn't in fact attached to tab 14, they moved to tab 14. And what we say is that there was no instruction at all by any of those methods. And what we say is that there has to be an instruction, and that's the effect of clause 20.
And how does that square with your claim against the employer?
So sorry.
How does that square with your claim against the employer?
CCM 222. The CCM 222 was a claim for extension of time. It's inaccurate in a number of respects. It talks about a change from single curvature to double curvature. It was always going to be double curvature. It talks about the panels being originally modularized and then becoming bespoke. It's on page 3. And the claim to the employer, as I say, was only was a claim that was put. It was rejected. It may have been ill-advised, probably was, but it simply does not support a case that BAM gave an instruction to vary the contract. And there is no instruction to vary the subcontract. And CCM 222 was a document upon which the defendants place considerable reliance. But it doesn't, in fact, affect the contractual analysis which Your Honour impressed upon him was the important point at all. Because the contract is expressly a fixed price contract. And 18.1 makes that absolutely clear. That's at page 1432. The subcontract price shall be the lump sum accepted subcontract amount and subject to adjustments solely in accordance with the express provisions of the subcontract. And the defendant's case invites you completely to ignore that. There is provision at 18.2 for remeasurement in a case where a contract provides for remeasurement. But there was no remeasurement in this case, and no remeasurement sought in this case. It's out of discussion. So you're stuck with 18.1, which says that the lump sum accepted subcontract amount, which is defined in Annex 2, Annex 3, I'm sorry, at 1449, is not subject to adjustment except in accordance with the subcontract. The subcontract is governed by clause 20. And that analysis puts paid to the submission at 14.6 in Affan's closings, which I say is an adventurous and false submission, page 38, that there are no debarring words in clause 20.1 or clause 3.0 to have the onerous effect, namely that in the absence of an instruction, the subcontractor is not entitled to additional payment for work instructed. That is simply not true. 18.1 rules out any additional payment, except in accordance with the only clause that applies, which is clause 20. And on the facts of this, our submission is that Dr. Affan was absolutely clear in his own mind that his signing the subcontract meant accepting the price, and that when he signed the contract, he took the risk that the price would turn out to be too low. And you asked him about that. The passages in my written clothing was paragraph 58 on pages 36 to 40. It includes a long passage from the transcript of day 4, precisely because it's an important passage. And the submission that the defendants make to the contrary on page 53 of paragraph 19.2, the claimant's self-serving new argument that somehow the first defendant inadvertently waived its rights to claim a variation for the instruction of a preferred panelization and panel sizing simply by signing the contract, they say, is wrong. The word simply signing the subcontract entirely underestimate the formal commitment that signing the subcontract involved, and they can't get away from the fact that they signed it. Furthermore, the defendant's submission that they should be allowed to get away with signing a subcontract and then not abiding by its terms is entirely contrary to the Article 246 requirement that the contract shall be implemented according to its contents. And there can be no argument on the basis of good faith against applying the terms of the contract, and none's pleaded. And the defendant's argument is inconsistent with Dr. Affan's evidence to the effect that they accepted the contract price and the obligation to undertake the works at the fixed price, knowing what was involved, without making a full calculation and taking the risk that the figures might be too low, but in the hope that Affan would get a variation. No doubt influenced, as you pointed out, by the leverage that Dr. Affan thought he had over BAM because of their unique position in the market. The next submission, that there was no instruction, it is based on our position that there is no credible answer advanced to BAM's contention that there was no instruction compliant with clause 21b. They never seek to address the point that their case has changed so radically from the pleadings to the opening to the tab 14 case. And I say the change of their case is important, not just in the way that it undermines the consistency of their case, but because it also demonstrates that the defendants have no real idea of when and how they say that a variation instruction under clause 21b was ever given to Affan. Their present case, we say, that the instruction comprised the red line drawing attached to the email on the 2nd of March, is entirely unrealistic. There was no instruction incorporated in tab 14. The defendant's submissions ignore the facts. First, that the red line drawing didn't show panelization, just a series of horizontal red lines. Secondly, that there was no written instruction in the email of the 2nd of March, indicating that it was a direction as to how to design the panelization. Thirdly, that email had 43 attachments with nothing to distinguish one from another. Yet the defendants claim that this one attachment, the red line model, uniquely constituted an instruction to change the entire panelization. Fourthly, that the email of the 2nd of March was in the context of seeking confirmation that Affan's offer was compliant with all the pre-existing IFC drawings. And that's letter 111, which is exhibit 1 to our responsive supplemental memorial. Fifthly, all the drawings, every one of them, in the attachment to the 2nd of March email came from the original IFC drawings, included with the letter of intent, also of the 2nd of March. And you have the correlation between between tab 14 and the IFC drawings as an exhibit to our closing submissions, written closing submissions. Those documents included the red line drawing, and that was a revision dated the 11th of December 2016. That's 1091. So that the red line drawing, which they say is the instruction to change the panelization based on work they did before at the 2nd of March, was actually an old drawing from the 11th of December 2016. That is an entirely impossible case. And the case that it constituted new instruction on panelization is completely inconsistent with Dr. Affan's evidence. This is 24th of October, page 5, lines 1 to 6, line 1 to page 6, line 15. And I'll repeat one answer. Page 5, line 6 to 12. There is no change presented by the email of the 2nd of March in the index of tender documents. My question. Dr. Affan's answer. That is definitely not correct. I'll tell you why as well. Because the architect on the 21st of February, he said he finished the panelization for 30%. On 27th of February, he said, I finished 80% of the panelization. So what was he doing? And it was not surprising that on the 2nd of March, he finished 100% of the panelization and were giving it to us. That was not in those documents. So what's he doing on the 21st of February? What was he doing on the 27th of February? He said it very clearly. Although we were not private, must be privy to this ACAMEX at the time, but you have it in your statement. That is said in spite of the fact that the red line drawing they rely on was a revision dated the 11th of December 2016. And that, they say, is the instruction for the new panelization. I then go on to make further points, but perhaps the point I've just made is the best point there can be. The red line drawing cannot be the instruction that they rely on to support the variation. I say that they haven't addressed our points on the original tender spanning floor to floor, and I set out our points on the tender in our closings. The very highest they can put it is on the basis that the original invitation to tender offered an option between 4.5 panels spanning midway and 9-meter panels that on any analysis span floor to floor. And I'd invite you to have another look at slides 11 and 12 of AESG's presentation in EV23. And even that doesn't help Affan, because Affan had design responsibility and opted, and plainly opted, we say, for the 9-meter panels, and design responsibility being imposed on them. They simply cannot show that there was any design imposed on them, and they cannot show that there was any variation which sought to change that design. So what they say is they have their design choice removed. But there is no evidence of any choice ever having been made as to panelisation, and no evidence of any change in that choice being foisted upon them. And there's no hint of any assertion that there was a change of complaint, a complaint of a change until the CCM 222 application from EOT was presented much later, and I've addressed you on that. The assertion in the closings by Affan that an instruction to span the panels floor to floor would be a variation of the subcontract, would only be true if they decided on a different scheme and if BAM had given an instruction in writing to change that scheme. But that's not what happened. Affan submitted its tender, which we say inevitably can only be read as a floor-to-floor spanning tender. That was accepted, and the parties then discussed collaboratively, as is shown by the series of meetings in March, how the design would be developed, and it was then developed and approved. And it was never intimated during that panelisation process or any of those meetings that Affan was or even might be entitled to any variation based on panelisation or panel sizes, and nor was it said that there was any change in their design. On the use of the word nominal, that was plainly Affan's choice. Mr. Hasnab gave evidence that he knew, and it was all clear, that there would be larger panels at the roof and lower levels, and that was never the subject of controversy or instruction. It was all part of the design development. Our case on nominal is that it means typical, as described by Mr. Haslam, certainly not that it means maximum, as seemed to be suggested by Mr. Moranti and Dr. Affan and Mr. Smith at times. The best evidence on this is from Ms. Kindle and Mr. Haslam. There was some deviation from the 9-meter panels in a relatively small number of panels at top and bottom of the torus. Typical panels were roughly 9x2x2 as originally envisaged, and some variation was inevitable. At one point, strictly a point on quantum, but it's relevant to this issue, at no stage, either contemporaneously or to this day, have we seen any analysis of how far the cost of producing a larger panel exceeds the cost of producing a 9x2x2 panel. No stage have we seen any point as to what any such extra costs might be in aggregate. And the reason for that is that the case was never put on that basis. They've never counted up the bigger panels. They've never said, well, we have to do so many bigger panels which we didn't expect, and they cost X, Y, Z per panel. There's been no analysis of that at all.
I think we're going to have to be drawing to a close.
I'm very close to it. I'm going to leave out what I wanted to say on quantum accepted principle, and I'll be finished within 5 minutes. They say there was no objection, no basis for objecting to their instructions. That's simply not the case. If they thought there was a variation, as you suggested to Dr. Affan, they could have said so. They could have sought confirmation of a variation instruction. They could have insisted that it be recorded as chargeable. And once the subcontract was signed, if they'd said there was a variation, they could have given notice of dispute under clause 30, and none was ever given. On hexagonalization, you have all the evidence on that. Again, I invite you to remember the reasoning of the engineer relied upon by Mr. Corden and the evidence of Mr. Smith, who agreed with me in cross-examination and said, I'm agreeing with you that the hexagons were introduced to improve the ability of the sheet to match the curvature of the composite panels. On quantum, all I'll say is this, is that an orthodox computation of a claim for a variation would have sought to demonstrate the extra costs occasioned by the variation over and above the cost of the works as originally contracted, by subtracting costs that would have been incurred by performing the originally contracted works and showing the extra. And that would have involved showing how many panels cost more, what they cost, why they cost it, and why they were larger. And I do invite you to look at the analysis in Mr. Corden's and Ms. Kinderland's report of the number of panels that deviated and how far they deviated. And she then did the more granular page showing the deviation of the larger panels. And to compare that with the way that the counterclaim has been put, the experts have agreed figures as figures, but we say that there is absolutely no basis for the claim that they've purportedly put, which is a global claim. And if they say the variation bigger panels, they've got to show how many panels were bigger, what each panel cost, what it would have cost, subtract the difference. That's the valuation of the variation. Hexagonalization, we've established that the change of orientation made no difference. The only extra cost is extra slices, extra cuts in the steel sheets to produce the hexagons. As to that, they have given us absolutely no evidence of cost. And we say that in any event, the drapeability was what caused the hexagonalization, and there was no instruction. And those half points that I have made. And Your Honour, I trespassed to a lot time enough. I'm sorry for running over. It's complicated, but there we are. I'm happy for Mr. Hussain to have equal time.
Thank you very much indeed, Lord Marks. Mr. Hussain.
Your Honour, I will address you in the following order. Firstly, claims against the second defendant. Secondly, claims against the first defendant. And then the lion's share of my submissions will deal with the first defendant's counterclaim for variations under the subcontract. Summarily, before I get there, just as a snapshot, the defendant's position is as follows. If we start with the claims against the second defendant, they're without basis. They were an afterthought, pleaded well after the claim was issued in the manner that they appear before you. None of the allegations of dishonesty under each of the three claims of fraud or reckless misconduct were put to Dr. Affan in his very lengthy cross-examination. And I submit that this alone is fatal to the claims. And you're obviously aware that there was no opening on these claims. If we then look at the substance of them, taking each in turn, the three acts said to constitute fraud or gross misconduct are not factually made out. The first allegation, if we go to the combined bundle pleas at page 4372. 4372. Just wait for it to come up. Is that in this letter on the 26th November 2018, the words Further to our previous letters and as requested at the meeting held at AIS office on 25th November 2018, related to the substantiation of 15 million requested on account for the project cost incurred. The allegation is that using the words project costs incurred means that Dr. Affan actually said that these costs had been paid to the subcontractors. And we say that they don't even get off the starting line. That is not what was said in the letter. And the letter cannot constitute an act of dishonesty. And we maintain our position that it should not have been pleaded by the lawyers involved. The second allegation is that the first defendants are putting in an application and that the claimant rejected for lack of substantiation was an act of fraud. You already see that Dr. Affan lay above a host of people managing this project. He wasn't responsible for substantiating claims himself. So he's already removed from the alleged dishonest conduct personally, but there is no dishonesty established. All that said is that the substantiation did not satisfy Mr. Doyle. My learned friend spent hours, well, not hours, but a large amount of time talking about whether or not dishonesty is established because a delivery note says Fashion Avenue Mall of Dubai. His suggestion, and he said today that it was plain as a pikestaff, was that tons of pre-preg were delivered to Fashion Avenue at the Mall of Dubai. I mean, that suggestion is absurd. They were delivered to the facility and they were interchangeable. The burden of established dishonesty simply is not met, nor do we say is the trigger, the basic threshold for pleading it and maintaining the case. And although my learned friend sought to dismiss this as an unattractive point, there is no damage said to arise from this alleged fraud. All that said is that Mr. Doyle spent some hours dealing with the file submitted. Well, that was his job. It's not suggested that extra people were hired or that Mr. Doyle was paid extra for this work. The third allegation is an allegation that by presenting undated security checks, Dr. Affan was dishonest. Now, my learned friend has entirely skirted the fact that these security checks were undated, which was a point that was emphasized by yourself and by me through the trial. Dr. Affan's evidence was that when he presented or when he gave the checks to the claimant, he checked the accounts and there was money there to cover the sums of the checks. The claimant has not been able to counter that evidence. The claimant dated the checks without asking or agreeing with Dr. Affan. And the basic point is, firstly, there's no dishonesty because Dr. Affan simply was not told at what date these checks would be presented. Nor did he make a warranty that the checks would be, that there would be money in the accounts at an unknown date. So that's the claims against the second defendant. I'll come back to them, but they can be dealt with quite shortly, and I'm not going to spend a lot of time on them. The summary of the claim against the first defendant is that it remains without any legal basis. Now, there are some barely asserted allegations of breach in the statement of case. None of those allegations of breach are said to have caused the additional costs over and above the contract price, subcontract price. It's not a case of saying, well, you were late by 2 weeks and therefore we had to incur 2 weeks of delay damages and so on. There is not a single breach linked to any of the additional costs. What is said instead is that these alleged breaches, it seems taken together, meant that, and my learned friend put it as highly as this, meant that the claimant was obliged to take over the works and carry them out itself. Well, no, they don't. It doesn't mean that. There is no causation established between the breach and the claimant deciding, we say unlawfully, but in any case, the claimant deciding that it wanted to carry out the work itself. And there is no basis, whether under the contract or under UAE law, in the absence of a termination or a cancellation, for the claimant to seek the additional cost of carrying out the work itself. In his speech today, my learned friend referred to an authority which appears attached to the pleading, to the closing, claimant's closing at CCL 17. If we can go to that briefly. So it's in the claimant's closing exhibits, CCL 17. I'll let you read that in your own time, Your Honour. But firstly, the translation of this this case is quite difficult to follow because it seems to be totally devoid of full stops. But I'll leave that as a matter for LexisNexis. But if we go to page 2 of the PDF, please, operator. And we see under the headline, if you scroll down, please, where it says first causation number 54121JY. What we see is that it says, whereas the appellant objects to the contested judgment stating that it erred in the application of the law and contained deficiencies in reasoning and flaws in inference, and breached the right of defence when it imposed upon it to pay the costs of completing the construction works through another contractor without the need to obtain a judicial decision thereon, on the grounds of the text of paragraph 24 of the agreement concluded between the parties on the 19th of September 1990, without applying the conditions of withdrawing the work therefore from, in the case of breach of its obligations stipulated in paragraph 26, including the necessity to serve 3 written notices. So this is a case involving the exercise of a contractual right to terminate, which was upheld at first instance. The contractual right to terminate was under paragraph 24 of the agreement. The appellant said, well, hold on, how can this be correct? Because paragraph 26 required 3 notices. This has nothing to do with what my learned friend is suggesting, that somehow under UA law, you can claim the extra over costs of completing the works without terminating a contract. And if we go over the page, page 3 of the, and scroll down, please. What we see, if we look at the words, whereas it is upheld that the court did not discuss the appellant's defence regarding its failure to notify 3 times. So what the court did was it said, yeah, the finding of first instance of a legitimate contractual termination is flawed and shall be reversed because it failed to take into account that notice under the contract, which was a precondition to contractual termination, was not given. This has nothing to do with the conclusion that my learned friend seeks for you to draw. Just wanted to draw that to your attention because that seems to be the only legal basis.
Sorry, can you just point to?
Yeah. So where it says where, so you see that heading second cassation number 44621.
Yes.
If you go about 7 lines above that, it says whereas it is upheld that the court did not discuss the appellant's defence.
I can't. Okay. Yes. Yeah. Thank you for highlighting it. Yeah. Okay. That's great. I just highlight it on my copy. Brilliant.
The passage on which I rely is the bottom half of page 2.
Let's have a look at that. Of course, the problem with reading these judgments is to know what is submission and what's holding.
I'll let you read in your own time. What is clear in my submission is that this case is considering a first instance judgment which made a finding of a lawful contractual termination, and that is a context in which the termination is being discussed. And the Court of Cassation reversed that decision, saying that the contractual termination was not lawful because the contractual preconditions of notice were not followed. This is not a case making what would be a remarkable finding that even in the absence of a termination or a cancellation, a main contractor or an employer can somehow just proceed to get someone else to do the work and claim the additional price.
Well, I too leave it to your honour to read the whole case in your own time and say it's completely clear, but
Okay, well, anyway, I've got the passages relied on. Thanks.
So and I'll come to this in some detail, but the claim against the first defendant, we say, simply fails because there is no legal or factual basis to argue that the first defendant should pay the additional costs of the claimant choosing to carry out the works itself. What the claim against the first defendant does help us with is that it shows plainly that even when the claimant carried out the works itself, they ended up costing nearly 3 times the subcontract price. And that makes it plain. And we'll come to CCN treble too, because I want to emphasize that at the start as a reality check or even a sanity check. What makes it plain is that something changed here. Now, my learned friend said to you at the start, when you put that to him, well, that was a risk that Affan took because they didn't properly price the bid. That is simply not a factual case ever put. And I emphasize this in opening. If we go to the bundle at page 386, when we look at the fact that when even the claimant carried out the work, 386 please, it cost nearly 3 times that much. That is in a context where this is the document production request. If we go to the final column, this is from the claimant. The claimant was asked to disclose the bids received from other parties, which it refused to do because it said those bids were immaterial. And the reason it said they were immaterial, if you look at the last paragraph on the screen, they said was the claimant does, furthermore, the defendants have mischaracterized the claimant's argument. The claimant does not allege that D1's tender was underpriced. So we start with the works, the panelization costs nearly 3 times as much as a subcontract price. The claimant is not suggesting that the price was an underbid. It's positively saying, no, we are not suggesting that. And then we come to something that my learned friend shirked for the good part of 2.5 hours till you put it to him, which is the factual account given by the claimant's own technical personnel and CCN treble 2, which was produced for the first time in an order given during the hearing. Now, Mr. Doyle, and you'll have the references to it, was clear that this document, CCN treble 2, was produced by the claimant's technical personnel, 1, and 2, he had no reason to doubt that the factual account they gave of what had happened, including the factual account at the structural steel meetings, which I put to him specifically, was true. So although my learned friend seeks to dismiss this document, this belatedly produced document, as something to be ignored because it's an extension of time claim or because he says it talks about single cured rather than double cured, he avoids the basic fact that this is an accepted contemporaneous factual account of what happened in those meetings, those very meetings, where we say there was an instruction to change the panelization. And I want to go to the document now because I want that to frame everything I say about there being a variation and how unrealistic the claimant's position is. So if we can go, please, to file 23. And within that, please, operator, go to claimant's disclosure. And you'll see CCN treble 2. Yes, please, it's document 2. And just using the PDF pages operator, if you go to page 6, we see the executive summary, and Your Honour, I refer you to the 4th paragraph from the top. Amongst the contract documents, the specifications explain that the detailed design is to be provided by the employer, and it is for the contractor via one of the pre-vetted permitted facade specialist subcontractors to integrate the detailed design with the selected specialist systems and proposed manufacturing solutions. It then continues in the next paragraph. Under the specification requirements described in detail in section 3.6 of the narrative, integration of contract IFC design with a specialist system is to be presented to the employer in the form of shop drawings, and following approval of those, a visual mock-up is fabricated for use as a quality benchmark for the subsequent permanent facade works. And then it says the contractor has no authority or obligation for the aesthetic design, which is provided by the employer in the contract IFC documents and which must be maintained. This is the correct, contemporaneous, factual account of BAM's own technical personnel's understanding of the contract. Neither BAM nor Affan were responsible for the aesthetic appearance of the design. They were entitled to follow the IFC design, which, as we know, very clearly states that the panelization is to be as per Affan's preference, Affan being the specialist subcontractor. We then go to the next page, page 7. Bear with me. First paragraph, 5 lines from the top. It says, soon after commencement, on the 8th of January 2017, it became apparent that the detailed design included in the contract IFC drawings provided to the contractor did not reflect the final complete design requirements of the employer. Although the employer representative's responsibility is to approve the specialist facade subcontractors' submittals to ensure compliance with specified requirements through weekly meetings, design workshops, the process of submission and approval of drawings and models, the employer and or employers' representatives and or employers' representatives consultants, collectively the design team, constantly and repeatedly changed, developed and enhanced their own design following protracted periods of indecision and instructing a multitude of mock-ups demonstrating various alternative configurations. Continues, the evolving changes, enhancement of the contract IFC design from commencement resulted in the delays suffered, which are described in detail in the interim submission. And then if you look at the last sentence in this paragraph, this period of completion of the design was led throughout by the employer and capital D, T design team, with the contractor and specialist facade subcontractor following instructions as and when issued. We then go to the next page, PDF page 8. It says, whilst this is the 4th paragraph from the top, whilst originally modularized as a result of the multitude of design changes, specification enhancements of the facade panels, they became individually bespoke and consequently resulted in changes to the fabrication process of the actual facade panels, culminating in the fabrication time for each panel increasing from 22 to 28 days and resulted in a significantly increased amount of wastage in the raw materials used. We then go to the next page.
But just pausing there, this isn't right, is it? Every panel was unique because of the calligraphy.
I think what they're talking about here is the sizing. Your Honor, you can see that very clearly because it says that the fabrication time increased. Well, you can see that more specifically when you look at when they go through the meetings.
Okay.
We then go to page 9. In summary, the contractor requests a time for completion to be extended by 390 days. And we know that there was a complete waiver of LDs finally negotiated. And we know from Mr. Doyle that that was because of design changes to the facade. So to come here and say on the last day of closing, well, there was no change to the facade is pure fantasy in my submission. It's just simply not a sustainable position. But what they also say is a specialist facade subcontractor was not in a position to evaluate the direct costs of the changes until such time as enhancements in design and the various iterations had been finalized, the visual mock-up approved, and the mass production of the panels undertaken. The direct costs are submitted separately. We haven't had sight of how those direct costs were submitted, and I'll look at that in a moment. But again, they're making
Just remind me of the date of this document.
The date of this document, Your Honour, is, I should have it. Why?
Just, it's not on the front, I think.
We do have a date for it.
Maybe it's at the end. I'll have a look at the end.
Yeah, I'll ask Mr. Blakeway to send it to me because I do have a note of when it would follow.
No.
We do have a date for it, Your Honour, from the
I'm sure there is. Yes.
We then go to PDF page 37.
Yep.
We have a headline delay events. And then we go to page 40, Your Honour. And you recall, we did not see this document till during the hearing. And Mr. Doyle confirmed that it was a true account presented, to his knowledge, a true account presented by the technical personnel at BAM. But it cannot concur more with the first defendant's case. So if we start with 7.3.3, I'm not going to read all of it.
Can we go back to 7.3.1? Again, Lord Marks says that this is in error when it talks about the original intent to have a single curve by means of faceted panels.
Your Honour, it may or may not be an error, but the point is that's entirely that point is entirely a distraction, because what we see is that they move then to talk about the panelization model and the killer preferred design that was then imposed. So talking about single skin or double skin is neither here nor there. What we then look at is how the panel sizing was instructed to be as per killer's preference. Sorry, I don't want to jump off the point, but I don't want to speculate about single skin or double skin. That does not change what follows in this document.
Well, it may have been that there was a drawing which showed a faceted design at one point.
Yes, possibly. I don't want to speculate on that.
No.
So if we go
I've not seen this drawing then. Yeah.
We go to page 40.
Page 40, yes.
So I've got a message from Mr. Smith saying that this is a true extract of the IFC design. So it seems to be that the point taken is that it shouldn't be described as single, it should be described as double curve, but it really is a distraction from what we see to do with the panel sizing from 7.3.3. It says panelization discussions kicked off as early as the 21st of February 2017, when the first steel facade weekly coordination meeting was held. And then we see at 7.3.6, weekly meeting 2, it was recorded that approximately 80% of preliminary panelization setting out was agreed based on a killer design preferred scheme, later named option 1A. That is exactly the first defendant's case. Killer design had a preferred aesthetic for the panels, which is what was followed on instruction through the course of these structural steel meetings and also in the models that were sent to us. sent to the first event. It was recorded that approximately 80% of preliminary panelization setting out was agreed based on a killer design preferred scheme, later named option 1A, or the BAM Affan were instructed to explore alternative panelization schemes, which were presented during the following 5 weekly meetings, highlighting their relative technical advantages and disadvantages. Then it then talks about the meetings on the 5th and 13th of March, meetings 3 and 4. The initial panelization draft model was presented during meeting 3, and in total 4 options for panelization were presented. Killer's preference, very close to the final approved panelization, and then lists out other 3 models. And this is consistent with what we were saying. Killer told us this is essentially the panel sizing that aesthetically the client wants. We then see weekly meeting 5, 20th of March, 2017. Of the above options, Killer's design was split into 2. It's consistently called Killer's design and Killer's preference. And so 5 panelization options were presented. In this meeting, options 3 and 4 were discarded by the design team. And then it says 7.3.9. It was during this meeting where Affan presented their first foam 3D model with KLD's preferred panelization layout. So this is clear as day that the panelization was the preference instructed by Killer Design. And obviously, if it wasn't instructed, then we wouldn't have this CCM treble 2, would we? There was no suggestion by Mr. Doyle. He was on the stand. He could have said, well, actually, this was a bit of a try-on, or that we were just simply passing on a claim from the subcontractor. He was clear and explicit in his evidence that his contemporaneous understanding was that these passages, which I took him to, reflected the true contemporaneous view of BAM's own technical personnel who have not been brought before this court. You will have it'll be useful when you read the closings to read the minutes of the meeting side by side with how they're being described in CCM Treble 2. And I said there's no doubt left that this was an instructed change for aesthetic purposes. And if we then go to page 69 under the heading summary, it says the above narrative clearly demonstrates a protracted and time-consuming events which significantly contributed to the delay in the specification compliant visual mock-up 5 being offered to the employer's representative on the 4th of February 2018. It then says the first line of section 72800 of the specification states, where particular requirements apply, these are given in the relevant system section. There are no specific or relevant sections within 72800 that deal with panelization and other things. And accordingly, these are considered variations to the quality, character, and timing of the works. The contractor was therefore not able to make any allowance for the duration of time to gain sight of these at tender stage. I just want to pick up a couple more references. We go to page 112, 9.8.23 to 9.8.2.3, again talks about the multitude of changes to the facade design caused the average panel production cycle to increase from 22 days to 28 days, which is mainly attributed to stainless steel processing and an extra curing stage as illustrated below. And then we see that the days to produce a panel have increased, which is exactly what, so if you can scroll down, please, operator. Exactly what Dr. Affan's evidence was. And then it says in 9.8.2.4, the panel being required to stay longer in the factory during production. That has decreased the production output, and we see that as well. We have not been given the claim that was put forward for direct costs, but if we go to another document that was disclosed during the hearing, so we go back to claimant's disclosure, file 23, and we'll see bear with me, it's the statement of taking over. Statement of taken over, the third document, please, operator. And if we scroll down, please, under the headline EOT as claimed by BAM, there was a claim made for 421 million plus AED, and Mr. Doyle confirmed that this includes not just prolongation costs, but also the direct costs of carrying out the additional work. So the suggestion coming to you and saying, well, nothing has changed, or there was no instruction for a change, is just simply doesn't get past the claimant's own records. And I would invite you to look at, Your Honour, two parts of, do you have the defendant's closing?
Yes.
Defendant's closing at page 62, please, operator. It's internal 62. Should be PDF 62 as well. So paragraph 21.19, I've quoted the important section of Mr. Doyle's evidence where I said it was being reported to you by your internal technical team, wasn't it, that there had been changes to the panels that had led to additional time and cost, correct? And he says yes. And then we see, if we scroll down to 21.21 on the same page, the exchange with yourself, Your Honour, where Mr. Doyle confirmed that in negotiations with the employer, the position taken was that there were design changes that caused the delay. And this led to the overall settlement, or this factored in the overall settlement with the employer. So CCM Trouble 2 is important because it shows what a plain reading of the meeting minutes shows, that there was an aesthetic preference for a particular panelization. Killer Design insisted on a preferred scheme, and it was uncontroversial within BAM, in the minds of its technical personnel, that this was a change to the contract and the subcontract. I can then, with that framing in mind, Your Honour, I can go very quickly to the first two limbs. For the claims against D2, if we can start with the defendant's closing at page 14. So Section 7 sets out how these claims were belated. Initially, it was just the second defendant was just named as a defendant, and it took several months of wrangling to get actual claims or causes of action against the second defendant, most of which were thrown out by Mr. Justice Gross, and all that remains now are the three allegations put under the CCL 2021 or 2015 before you. We then go to page 17 of the closing. The starting point is that each of the three allegations of dishonesty were not put to Dr. Affan. It was not put to him that he was acting dishonestly when he wrote the letter of the 26th of November 2018, or that he was acting dishonestly in making presenting a claim for further payment, or that he acted dishonestly when he presented the undated checks. That is a matter of record. In fact, when we had the hearing on the 12th of December, the claimant sought permission to put this to him, and Your Honour rightly said, no, that time has gone now. So it is not an answer to that for my learned friend to say, well, it should have been obvious to Dr. Affan if he'd read the pleadings or he'd heard Mr. Hussein's objections to the claims being maintained. That is not what the requirements are. We are in public proceedings in the DIFC courts. The proper procedure has to be followed, not least because of the precedent it would set otherwise to other defendants in this court. We have set in the closing at page 18, paragraph 8.5, the decision in Amira Foods versus the IDBI Bank, that the DIFC courts rightly can apply the principles in Brown v. Dunn. And I'll leave that to your honour to look at. With that in mind, if we look at the three allegations, we start with the first allegation, which is at page 19 of address in page 19 of the closing at section 9. Let's just look at how the allegation is actually pleaded. So if we go to the particulars of claim at page 26, please, of the combined bundle. We see at paragraph 56 the summary of the three allegations. We then see a paragraph 59, allegation 1, misappropriation of project costs. And the allegation of paragraph 60 is that there were sums claimed which were not paid to the intended suppliers. And if we look at paragraph 66, this is the actual allegation made. In the premises, D2's claiming the above sums on the basis that D1 had paid or would pay the relevant suppliers was fraudulent and dishonest. Now, I don't understand how the would pay could constitute a ground for fraud, because by definition it would mean if you give me this money, I will pass it on. And the money was not paid in full. So the case really is that there was a representation that these sums had already been paid. And as if we've looked at the letter on 4372, I'm not going back to it, there was no such representation. It talks about a cost being incurred. That is not the same as a cost being paid.
But implicit in it is that these will be discharged. The allegation is that there was no intention to discharge them.
Yes, but there's no smoking gun to establish that there was no intention.
Well, yes, I mean that's an evidential issue.
Yes, but if the case being put is that which is one of the cases being put that it has been paid, there's simply no representation that has been paid. If the case being put is, well, if we pay this money to you, you wouldn't have passed it on. Well, firstly, where's the evidence for that? And secondly, where's the dishonesty? You also be aware, Your Honour, while we're here, that even if all of this is correct, if we look at the chart at the top of page 21, of the closing, sorry, page 21 of defendant's closing. I'm sorry, operator. The suggestion that Dr. Affan would be personally aware of who had been paid what and who would be paid next to the point needed to establish dishonesty simply does not arise. It's an unrealistic suggestion. And I'll leave you to look at the detail of what we said here about the evidence. We then look at the second allegation, which is at page, 27 of the written closings. Operator, if we can look at how this is actually pleaded to the particular claim at page 30, please. Particulars of claim, please, at page 30. So combined bundle, page 30. I'm so sorry, operator. Combined bundle, page 30. I'm looking at paragraph 74 and, sorry, 73 and 74. D2 knowingly submitted invoices for reimbursement of costs and materials allegedly purchased for the subcontract when a higher proportion were for materials not applied to the subcontract at all. And then it says, somewhat surprisingly, according to the claimant, claims damages from D2 arising out of his fraudulent claims submitted for reimbursement. However, since in the event the claimant never paid D1 in respect of these reimbursement claims, the claimant's claim in respect of these claims is limited to the wasted cost of investigation. So if we just pause there, and the detail in the written closings, I'm not going to repeat. But the simple point is, even if we can personally attribute this level of knowledge to figurehead of the company, Dr. Affan, his point was, his understanding was that the materials that were being claimed, although they hadn't been earmarked in the invoices for this project, were in fact intended for use in the project because they're interchangeable. Now, the only way around that, offered around that, is the very lengthy cross-examination by my learned friend, where it was said that because certain invoices say Fashion Avenue, Mall of Dubai, or the like, they wouldn't even have gone to D1's facilities. And that is plainly wrong. You don't deliver tons of pre-preg material to the Fashion Avenue. You deliver them to the facility to be able to use it to create the composite panels. I'm just surprised that this point is still being run. And you have my point.
That was the point.
Sorry, I didn't hear you, Your Honor.
The invoices recorded delivery. I spoke. I'm sorry to interrupt, but the invoices recorded delivery and delivery notes. That's the point that was put.
Well, in fact, we don't know whether that was a way of allocating it to a particular contract or whether it was actual delivery. But as I understand the position, pre-preg is used to make panels. The question is, are panels fabricated on site or are they fabricated in the factory?
These were notice invoices for the delivery of pre-preg to Dubai Mall, Fashion Avenue. And on the right-hand side, top, there were boxes which I took the witness to show that the deliveries were actually made to DNFA.
I'll have a look. I'll have a look at that.
Your Honor, I'll continue, but I think that it would be madness to suggest that tons of pre-preg material were taken to a fancy exclusive shopping mall in the middle of Dubai. There is no manufacturing facility in that mall. We're now clutching at really going beyond the realms of reality.
But but the real issue is this, isn't it? That if it is said that a dishonest claim for materials that were not utilized on the contract was made, that could simply be demonstrated by measuring the quantities used on the contract against the quantities purchased. And
correct,
if the quantities purchased exceeded those used on the contract, that would prove the case.
Yes, Your Honor, and this is the point we made in the written closing in some detail. And that would be a fact-driven approach, rather than flinging out an allegation of dishonesty first and then seeking to validate it at any cost after, which unfortunately seems to be what's happening here. you have the point that there's no damage claimable under the CCL here. The suggestion that there's been a loss of money to the claimant of Mr. Doyle's time is just fanciful. The third issue is the one of the issuing of security checks. Your Honour, if we can go to the written closing, which is at page 31 of the defendant's closing. And it's dealt with in some detail here. It's worth looking at the combined bundle at page 32 to see the allegation, how the allegation is pleaded. Paragraph 83, it is the claimant's case that D2 must have known that the said checks would be dishonoured upon presentation, alternatively being reckless as to the prospect of their being dishonoured. Well, this is just simply unfeasible. What does the claimant aver was the date at which D2 would have anticipated the checks would be presented? It cannot aver such a date because the checks are undated. So it makes it impossible to make this allegation of dishonesty. If the date taken is the date of giving the checks, then the evidence very clearly from Dr. Affan was that at the date of issuing the checks, he checked the accounts and there was money in there.
I guess disclosure could have been sought as to the bank balance of that day.
Yeah, it wasn't, but also recall that the access to the accounts is, to my understanding, been limited precisely because of the presentation of the checks and so on.
Okay.
But the references to the evidence is at paragraph 12.10, where he says he didn't give them permission to date the check, and that at the time of giving the check there was money in the account. Sure, and I'll leave you to deal with that case. And the next one I'll deal with this very briefly because I don't want to be distracted, and it is a distraction. Is that you are told in the defendant's closing at
Defendant's closing or claimant's closing?
Claimant's closing, I'm sorry, at page 74. Paragraph 146. There's actually a headline, dishonesty in general presentation of Affan's case. So not only is the defendant and his team now persisting with dishonesty allegations that were not put to the defendant and which we say should not have properly been pleaded, they're now throwing out further allegations of dishonesty, but we don't know where these go. It seems to be suggested that for the allegations of fraud in 2018, you should make a finding of fraud based on conduct of the litigation. That's just plainly a nonsense. So I'm struggling to understand what the relevance of these throwaway allegations of dishonesty are, paragraph 147 of the closing is set to be. If they go to credibility as such, that's fine, but there's no need, and in my submission, no proper basis to allege dishonesty as opposed to lack of credibility. The four items said to constitute evidence of dishonesty, if we look at paragraph 1471, is that Dr. Affan mounted a case based on the minutes of the structural steel meetings that there was a variation. CCN treble 2, our paragraph after paragraph says there was a variation because of these very meetings. There's simply no basis for the claimant and its legal team to be suggesting that this is somehow evidence of dishonesty. Then says that there was a pivot from relying on the 13th of March meeting. There is no pivot. Our written closing is very clear that there were repeated instructions both at the meetings and in the model sent to our client. There's no pivot, nor is this evidence of dishonesty. And then finally, we have this issue about the Katia model, which, as your Honour has noted, I've said is a red herring. Now, what's being suggested, and I'll come to this, is that there's some kind of CATIA model out there that would uncover that the first defendant always wanted to build larger panels. But no explanation is given that why it would then price for 9 by 2.2, and I'll look at that in a moment. But if we go to the transcript for the 29th of October, Your Honour. And we look at, bear with me. Page 15, transcript of 29th of October. Operator, do you have access to the transcript, or are you able to find it?
We do not have the access to the transcript, sir.
I don't. My transcripts end to the 28th for some reason.
Okay, I'll read out page 15, line 29 through 32.
If you bear with me 1 second, I might find it in my emails. So I ought to have it. Bear with me. It will have come to me from Terrace, I guess.
Your Honor, I'll
You
just
read it.
out. Yeah.
Yeah.
The order, Your Honor, you gave, and this is how I understood the order. You said, let me give you a guideline. It sounds like you're going to get access to the whole model. As far as the application is concerned, it also looks like Mr. Hussain is saying, well, you can trace through the development to the 8th of March. I will be uncomfortable if you trace the development beyond that because you've not asked for it. So the order was to allow inspection of any parts of the CATIA model that were issued on or created on or before the 8th of March 2017. Now, what we see in the, if we can bring up the joint report of Ms. Kindelan and no, it's the report of Ms. Kindelan and Mr. Florian. That's it. I think it's headed facade. We go to page 7, please. They say on the 11th of, this is paragraph 2.1.1, on the 11th of November 24, the technical experts from both parties met at Affan's facilities to inspect the CATIA model. Due to security measures, access to the model was restricted to a specific computer connected to the internal network without internet or company network connectivity. The experts informed that during the construction phase, the project was saved on a physical server labeled Q. They then say that they were given 4 folders, of which 2 were relevant to the Museum of the Future project. They say that they looked at these folders and they complained that they weren't, into their mind, collated in a way that was easily accessible to them. At no stage during this inspection did DLA write to Horizons with the various conspiracy theories that have been put to you. It was not suggested that a further inspection was required, or they wanted a follow-up, or they wanted this, that, and the other. The next thing we heard was the alarmist, and in my submission, entirely unnecessary submission to you for a further hearing to air out grievances. But there is no suggestion that there was somehow a model before the 8th of March. What we cannot prove to you the non-existence of something that doesn't exist. So the idea, I mean, we just, even before we get to the motivation, which I'll come to when I'm looking at the counterclaim, the idea that there's some kind of big, huge conspiracy theory, if there was something further that they thought they hadn't seen, why was that not brought to Horizon's attention at the time of the inspection? It wasn't. Instead, what we've jumped to is an entirely, in my submission, improper allegation that Dr. Affan personally gave instructions for files to be somehow withheld or hidden without any inquiry with Horizons before making this allegation. What I don't want to spend much longer on the allegations of dishonesty, because they are, in my submission, so self-evidently flawed and unsubstantiated. However, my client, Dr. Affan, is one of my lay clients, has faced these very public allegations in public court proceedings, and we would ask, if your Honour upholds our submissions, that in light of protecting future users of this court, and in recognition of what Dr. Affan has been put through, that due note be taken as to the conduct of this claim, and that it be dismissed. We then go to the claim against D1, Your Honour. We can start with the defendant's closing. At page 5. So we're looking at defendant's closing, please, operator. Page 5. John, I'm conscious it's 2 hours since the last break. Would you like to have a brief break?
Yes, I was. Yes, I sort of lost track of time, really. That's probably a convenient moment. Shall we take? Should we take? Well, it's 2 minutes past 1 UK time. Shall we come back at 1:15?
I'm grateful, Your Honour. Thank you.
Okay. So that's 1:15 UK, 5:15 Dubai. Thanks.
Your
When
Honour,
you're ready.
Your Honour, I'm going to briefly now look at the claims against D1.
Yeah.
So the way the claims are presented now, based on the amendment, is that they are now only presented as claims for breach of contract. However, even now it's difficult to follow the logic of the claims. By logic, I mean the legal basis of the claims. And in my submission, that is because they lack a proper legal basis. But if we look at how it's presented now in the defendant's, in the claimant's closing, if we go to the claimant's closing, please, at page 26. I'm looking at paragraph 30. See a headline, rationale of BAM's claim for damages. It says BAM's case on its damages claim in summary is that as a consequence of breaches by Affan of the subcontract and the addendum, it had no option but to take over the subcontract works from Affan. The word takeover is not capitalized, not explained, and to pay for their continuation and completion to enable handover to the employer. So that it's called no option. And then if we go over to page 27, next page, paragraph 34 for closing, it says, Affan further contend that it is for BAM to show what particular costs are attributable to what individual breaches of contract. However, in the circumstances of this case, that is not correct and would not be correct even as a matter of English law if it applied. And then it says, the multiple breaches of contract on the part of Affan obliged. Now you see the word obliged, which is something my learned friend repeated. BAM to exercise its powers under the addendum fully, to take over the subcontract works and to pay for that. There's no statement of where this obligation is set to arise from. And then we see the word that was necessary because, among other reasons, BAM needed to protect itself from liability as main contractor to the employer, and therefore needed to complete its contractual obligations to the employer, which Affan was failing to facilitate. So the claim is now presented as damages for breach of contract. It's accepted that there is no particular damage said to arise from any of the particular breaches. The causation is simply this assertion that BAM was obliged or had no option or was necessary for BAM to do what it did. That's under the label of takeover, but obviously takeover is not a legal term. So if we pause there, that's the case that's been put to you, Your Honour. If you look at these breaches of contract for which these hundreds of millions of dirham are claimed as damages, those breaches are set out at paragraph 20, page 20 of the combined bundle. Page 20 of the combined bundle. Just looking at them, we see immediately that there's no damage set to arise from the breaches as such. So, for instance, there's a reference to unauthorized suspensions of the subcontract works. There's no suggestion that X amount of money was lost because of a period of suspension. Likewise, failing to provide sufficient labour and supervision to progress the subcontract works. Again, there's no suggestion that X amount of money was lost either because of delay damages up the line or because particular staff had to be employed in the period of breach and so on. There's simply no causal connection between the damages being claimed and the alleged breaches. That's because there is no causative connection. So if we look at the next page, top of page 21, lumped in there at 43.8 is failing to provide various quality records and design elements. What on earth does this have to do with the hundreds of millions being claimed now? And at the same time, you're asked to assume, because Affan has not responded to these entirely vague allegations on the basis that simply they do not go to the damages being claimed, you ask to assume, well, at least a breach is made out because Affan hasn't suggested, hasn't countered the existence of the breach. Well, that's not how it works. Burden of proof works. The burden of proof is on BAM to show that these breaches occurred. It has not discharged that beyond headline allegations. And then it runs into the brick wall of causation. These breaches did not cause the sums being claimed by BAM. Those sums were incurred because of BAM's own decision to conduct itself in the way that it did. And the reason we say those sums are so high is because the works were varied. That's why they're so much higher than the subcontract price. But even if there were no variation, BAM can't, on the one hand, take over, in his words, the works, prevent the first defendant from carrying them out, and then say, well, you're responsible for our cost of carrying them out ourselves. The only route to that would have been either to get a cancellation of the contract from the court, which was not deliberately not done, or to operate a contractual termination, which is permitted under UAE law. You just have to operate it as per the contract. There may be a controversy as to whether you need a court's approval to operate the contractual termination. I don't need to take a view on that one way or the other, because a positive decision was taken not to terminate the subcontract because BAM wished to have the benefit of the specialist license that Affan held. So there is simply no legal basis, and the case mentioned as CCL 17 doesn't establish a legal basis whereby a contractor can simply say, well, your breaches are really bad. I feel like I want to carry out the works myself. I'm not going to terminate you, but I'm just going to withhold your management and control of the works and charge you the extra other cost of carrying them out myself. There is simply no legal basis for that. If I had to get into it, there is also no basis for what the takeover for this takeover of the works, which was an exclusion of D1 from managing the subcontract works. There's simply no contractual basis for it. We start with just bear with me. the subcontract at page combined bundle, page 1429. Combined bundle, page 1429. If you scroll down to clause 11.1 and 11.2, contractor shall from time to time make available to the subcontractor such part or parcel of the site and such means of access thereto within the site, which shall be necessary to enable the subcontractor to execute the subcontract works in accordance with the subcontract, which is an essential term of the subcontract, as one would expect that the subcontractor is given access to carry out the works, and that includes managing carrying out the works. And if there was any doubt about it, the definition of site includes a facility. So we go to page 1966. This is the addendum. Item B1, scroll down, please. Last sentence, the definition of the capital S site under the terms of the subcontract shall be deemed to include the facilities. So what does the claimant say founds its right to take over the works? So just before we get there, there is a subcontractual notion of taking over, which is at page 1431. Page 1431, which is, as we would expect, a taking over on completion. Do we see clause 17.1? Subcontract work shall be taken over by the engineer and or the employers as an integral part of the main works, in accordance with the procedures defined in the main contract. And that is to be done upon a certificate of completion or a notice of completion. So that's not the taking over that took place here, obviously. And while we're here, if we go to page 1438, you see clause 26, if we scroll down, please. The contractual termination clause, which was deliberately not operated. And had it been operated, you would see at clause 26.2 the financial consequences that would flow for a default termination under clause 26. Obviously, this was deliberately not terminated. We then go to the particulars of claim at page 22 of the bundle. The claimant has listed in the particulars of claim 4 clauses of the addendum that it says entitled it to exclude D1's management from the works and to pay for them directly. None of these allow that. The first reference is to clause B1 of the addendum, which refers to full unimpeded access and use of the subcontractor staff, equipment, documentation, and any other things as required. Words unimpeded access do not mean that BAM gets to remove the first defendant's access to the site itself or to remove the first defendant's management from the site. That is not what clause B1 says, and the very clearest words will be required. And the zinger in each of these is not only would there have to be a right of takeover as suggested, a right of exclusion, but there would then have to be something in the contract that says, if I exclude you, I can then get from you the actual cost of completing the works. None of these clauses say that. The next clause I refer to is clause B2. Contractor will take full benefit of the scope of the works related to MOTF only in terms of the facilities and resources until completion of the subcontract works. All this is geared to is that the facilities will not be used for other works. It does not mean that BAM has a right to exclude Affan's management from site let alone to then charge Affan the cost of BAM carrying out the work itself. The third clause I referred to, clause B5, and we start seeing how tenuous these arguments are. The contractor shall control the facilities and put in place its own security measures. Yes, they will provide security for the facilities. That does not mean A, that they can exclude Affan's management, and B, having done so, that they can claim the extra over costs of carrying out the works themselves. In fact, what we see in this very clause is a reference to practical arrangement for access shall be permitted for the subcontractor's operations. And finally, clause C7 is referred to. Full use of any equipment, material, or thing within the facilities upon taking over or subsequently delivered to the facilities shall be to the benefit of the contractor until completion of the production of the panels. The benefit of the contractor means the facilities will not be used for other projects that Affan may have going on. It does not mean, A, that Affan's management can be excluded from site, or B, that having done so, BAM can claim the extra over costs of carrying out the work itself. So there is no contractual justification for the actions that BAM took. Had there been such a justification, there is nowhere in the contract any basis for saying that BAM can then proceed to claim the cost, the extra over cost of carrying out the work itself, nor is any basis for this in UAE law. Just a minor point, Your Honour, it was suggested to you that there was not enough objection by the first defendant to the actions taken by BAM. I'm not sure where that goes. The actions were either lawful or unlawful. They plainly were unlawful in our submission. The action was taken as part of, in our submission, a concerted attempt to make it impossible for Dr. Affan to protest, because the security checks were placed and the bonds were called, which meant that he was put under immense pressure personally. But the suggestion that there was no objection is simply incorrect. If we go to page 2537 of the combined bundle, we see the letter of the 15th of June 2019. I'm writing to draw your attention that BAM has occupied and restricted the access of Affan employees to its facilities at Al Tire and at GGI factories. We believe they attempted to fabricate the panels themselves or together with their partners Fiberex, as we've been informed by BAM. I would like to put on record that the production of panels of your Museum of the Future is very specialised, and neither BAM nor its partner have the experience nor the skills to carry out this task. And then it says, next page, I would like to confirm that there has been no production of panels by Affan since 25th April 2019. BAM is still to honour its financial commitments and pays dues to Affan. In view of the above, Affan puts on record that it cannot take any responsibility for the action and performance of BAM. This is a very clear statement to the employer that BAM has been restricted from carrying out the works and that it will not take responsibility for BAM's actions. So if it were relevant, this is on the record. You will have the detail of our case on this in the written closing, so I'm not going to spend more time on this. I want to move on now to the counterclaim. And if I can go to defendant's closing, please, at page 37. At section 14, and I want you to look at this, Your Honour. In my submission, the defendants would urge you to look at this in the prism of CCM treble 2, in the prism of reality. So we've set out the subcontract terms for variations. Your Honour has rightly pointed out, I think you referred to, the question is whether there should have been a variation, capital V, The test is whether there was an instruction varying the works, not whether a formal variation was given. And we have dealt with this very point at paragraph 14.9, page 1339. So I'm not going to go over the contract clauses any more than what's in writing. What we've then done, Your Honour, in the closings is to take this in stages. And the first stage is that the subcontract permits the first defendant to size the panels as it sees fit. And if we scroll down to section 15, and we've set out the repeated statements in the tender inquiry and in the tender drawings, which say this: module sizing to the contractor's preferred design. And you have those references, Your Honour, they're well travelled. I'm not going to repeat them. What I would go to is paragraph 15.7. There seems to be a key point. One of the two key points taken is this timing point. And like most cunning points, it's a bad point. What's being suggested to you is, despite the obvious price overrun, despite the fact that there was a clear view within BAM that there was a significant design change, hence CCN treble 2 and the waiver of delay damages. Despite all this, there's a gotcha. The gotcha being, well, you signed the subcontract at a date when you already got the instruction. But the subcontract includes all these drawings, all these documents that are listed at paragraph 15.1 through 15.6. Each of them say that under the subcontract, Affan will size the panels as per its preference.
Can we?
So it doesn't.
Sorry, can we have a look at? It's slightly off your point, but I had some difficulty in understanding what the drawing at 15.6 was, and I'd certainly like a little help with that.
Yes, of course. It's so operator. If we go to file 23, spare me on.
Oh, 20, I've got it, yeah.
Just bear with me.
Sure, R23.
This is 934. So operator, I believe it's you'll see a drawing headed 121 and it's got 934. It's a PDF. Do you see, operator? It's just, yeah, there it is. Oh. I'm again something different.
No, that's the drawing that I just couldn't quite understand the orientation of that.
I'll try and assist you, Your Honour. It's just I seem to have opened up the wrong thing. Bear with me. Ah, there you go. You know, if you ask me the specific question that you have, I'll try and get assistance. I'm sure I wouldn't know it myself, but I will try and assist you.
Yeah, there's also a detail on it, which I think it's that drawing. Yes.
So, operator, if you open up 934 and you expand it to about 125%. I think we can all open it ourselves. Yeah, there we go. Your Honour, if you help us with where you want us to go.
Yes, could it just scroll down, please? I'll tell you. Okay, stop. Yeah, the panel height 450, typical depending on contractor design. I was interested in that as well, but I couldn't quite understand the orientation of this I assume that the circles are part of the diagrid, but the diagrid goes off in different directions. So I didn't know whether I was looking through a vertical or horizontal section.
I've WhatsApp for help, Your Honor, and I'll try and answer your question.
I assume
I don't
CL
know
to
off the top of
CL
my
is
head.
center line to center line. And panel height 450, typical depending on contractor design, seems to indicate then that panels were being fixed midway.
Yeah, so we've relied on this
than
obviously to answer the point which we say is no longer a runner, that somehow there was an error in choosing 9 by 2.2 because the panels could only rest at floor level. And obviously this
Yes.
shows that this supports Dr. Affan's evidence that no, they could rest anywhere on the tops.
Yes, well, it rather looks like the design intent here was that the panels were smaller than 9 meters. They were 4.5 meters, and rested between the center lines of the diagrid.
Yes, Your Honor, I'll come to that. I mean, I think that's consistent with, if we go to the closing, just the top of page 40 of the closing.
Yes.
The quote from the previous drawing, the table, it gives the option of 2.5 by 4.5 typical modules and 9 by 3. And I think this is something we went through. Is
yes.
that weighs against the point which Ms. Kinderlin accepted. She simply was not able to support that actually 9 by 2.2 was a mistake because you could only rest the panels at floor level.
Yes. Okay. Thank you. But anyway, if I could just be helped to visualize what that is at some point, that would be very helpful.
Yeah, I'm just gonna.
No, don't let me take you out of your. I mean, if somebody pops you a WhatsApp, come back to it later.
Sorry. So that's the first point, that the contract, the subcontract is clear that Affan would be entitled to size the panels as it sees fit. And all these instances where this is repeated again and again and again were carried through into the subcontract. They didn't just dissolve in the bid. The subcontract list of documents and the letter of intent list of documents says that this is what will happen. So the cunning point thought of against the reality of what was being reported by BAM itself at the time. Well, we've got you because you signed the subcontract after you knew that they wanted bigger panels. Doesn't go anywhere because a subcontract still continues to say, by incorporating these drawings, that Affan should be entitled to size as it chose. And the fact that it was instructed not to size as it wanted to, but to have bigger panels running floor by floor, will be a variation regardless of whether it was instructed before or after signing the subcontract. So that's the first point, that the subcontract permitted D1 to size the panels at 9 by 2.2. The second point, which is page 40 of the closing at item 16, is that D1 intended to size the panels at 9 by 2.2. And we quote first from the commercial proposal. What's picked up is this word nominal. That it only appears once in the commercial side, doesn't appear in the technical side. But nominal in our submission clearly means, from a commercial perspective, that they could go up a little bit. It doesn't mean that it will be spanning floor to floor. We then go to the next page, and we see that the technical proposal also states 9 by 2.2 repeatedly. You see that 16.4 through 16.6. We then see at 16.7 the quotation that the program is, just bear with me because full quote. That was based, sorry, if we go to page 938, just to put this in context. (938) of the combined bundle. Affan will be implementing a new production line in a new facility specifically designed to suit the production of 60 to 80 panels per month. And then we see over the page what that program is based on. And that's 60 to 80. If we go to, I'll take you to, Your Honor, if we go to file 23, and we are looking at tab 3, please. Tab 3 says it comes down. It's actually called tab 3 operators towards the bottom of the list. I think that's it. Yes. So in response to a query, we scroll down to item 12. The 60 to 80 panels monthly output is based specifically, you'll see, on 9 meter by 2.2 meter panels. So the program is based on this. And then also importantly, if we go back to the combined bundle at 749, the pricing is very clearly based on a 9 by 2.2. So this new conspiracy theory, if I can put it somewhat pejoratively, that well, actually it was always intended to go floor by floor. If that was the case, why on earth would Affan have priced for 9 by 2.2? And why would
show me the price? Sorry, would you just show me where the price is? Forgive me.
Next to item A, Your Honor, it says calculation of panel 9 by 2.2, 20 square meters.
Well, 9 PU polystyrene panel.
Do you see the blue?
Oh, that's okay. Yeah, calculation. I've got it. No, thank you.
And I put this to Mr. Kenyon from memory. It's common ground that the 125 million is based on 9 by 2.2. So the first theory that Dan presented was, well, actually, yes, it was priced at 9 by 2.2, but that was a mistake because the structure can only support the panels at floor by floor level. That failed. Even Ms. Kinderland said she couldn't support that there was no structural analysis behind it. When that failed, and the obvious question became, well, if it was possible to have 9 by 2.2 throughout the building, why on earth would Affan have done something more expensive than it needed to? That's when we started getting this argument, well, actually, there's a CATIA model that we've never seen, but must have existed, that showed that Affan always wanted to have larger panels. It's just simply not a realistic argument. Why would Affan want to have larger panels when it could have 9 by 2.2, given that it could rest them anywhere on the structure? And there was no restriction on what the size would be. Why would it do that? Why would it build something more expensive than it needed to? And secondly, why would it price for 9 by 2.2 if it intended to have bigger panels? Simply, the conspiracy theory doesn't get off the starting block. I'm going slightly out of turn because what is added as a counterpoint to the clear intention prior to the instruction to size the panels at 9 by 2.2 is Mr. Haslam's evidence. Mr. Haslam's evidence is not reliable. Mr. Haslam was taken in cross-examination to repeated letters he had sent saying that the panel sizing had increased and that this entitled Affan to additional time and money. He said on the stand that those letters were true. In light of that, his evidence that somehow actually was always intended to build bigger panels simply cannot stand. If we go to the closing at page 64, please. I'm looking at paragraphs 21.27. I'll invite your Honour to read that through to 21.29. The 21.27 was when he was taken to the letter asking for further time. And then 21.29, we scroll down, quotes his evidence when he was taken to the letter of the 29th of October, where there was a application for additional payment due to size increases, not just time, but payment. And I put to him very clearly, it was your honest understanding that the panel size will increase on instruction, and this entitled Affan to further monies, yes? So yes, there were a lot of changes in the panels, yes. He hadn't thought of these letters when he wrote his statement, but his evidence simply cannot stand in the light both of the letters and his admission that this was his honest understanding. He could have said these letters were try-on and that he was being dishonest when he wrote them, or commercial, or whatever. He didn't. He said very clearly, yes, this was my honest understanding. And what's not explained is that if Mr. Haslam did, according to his new witness statement, take a view that actually the panels were going to be bigger, why on earth would he allow a pricing combined bundle page 749 based on 9 by 2.2? That would be suicidal for his client, for his employer. Why would he allow that? It doesn't add up. So we submit that it is clear that the intent prior to the instruction was to size the panels at 9 by 2.2. And that's also borne out by ECM Trouble 2. So we then come to the third part of the case, which is the instruction to have larger panels. So page 43 of defendant's closing, Your Honor. Section 18. We've submitted, Your Honor, the two models that we say were sent representing the design that was to be followed, the Rhino models from Killer Design, the first and the second of March. That's set out at paragraph 18.1 through 18.4. And then a revision of that model that was sent on the 6th of March, which is set out at paragraph 18.5. Now, my learned friend has repeatedly said that this is a pivot from the case that the instruction was given in structural steel meetings. It is not. The case is that there were repeated instructions to follow Killer's preferred design. And we say that paragraph 18.7. Page 45. Thereafter, repeatedly in facade meetings and presentations, the outcome of which was recorded in writing in agreed Bureau-Happold meeting minutes, D1 was instructed to build a visual mock-up and issue shop drawings based on panel sizing shown in the Rhino model issued on the 2nd of March 2017, showing panels spanning floor to floor. Each of these comprises a further instruction to D1 to design and construct panels that span floor to floor. This is a variation to the tender, the letter of intent, and the subcontract, which made clear that panel sizing would be to D1's preference and design. What we then see at paragraph 18.9 onwards is we set out the clear instructions to follow Killer's preferred design. I'm not going to go through the detail of that, Your Honour, but what I would ask you to do is to hold these side by side with the surmising of these instructions in CCN Trouble 2, BAM's own contemporaneous truthful account. We've set those out at page 53 of the closing. And you see paragraph 19.3, the claimant is taking this wrong position contrary to his own documented position in CCN Treble 2, where the claimant's personnel factually record that the panelization was an instructed change to meet the employer design team's preference. This just simply is a nail, final nail in the coffin of this strange, unrealistic position that nothing changed, that there was no instruction for a change to the panel size. I would ask you to go, and we've set this out in a kind of linear manner. Obviously, I'll leave it to your Honour as to how persuasive you find that, but it is set out in a chronological way and in a concise and clear way, so that you may go through it. That we say was the instruction. A jury point taken is, well, why didn't you object? Object to what? The subcontract obliges Affan to follow all instructions by the employer and the engineer. And can I just pause here to remind us something that I started with in opening? The employer was the alter ego of the royal family. It was not an employer that one could somehow be intransigent with. The employer acted perfectly properly in saying, well, I want a different aesthetic. That's fine. That's a landmark of Dubai. But that means that there was a variation. The flip side of what's being suggested now, well, if it was so unrealistic and that no one thought it was a variation or a change, why on earth did BAM submit a massive variation claim and get a full waiver of LDs? But there was no change. Let's not forget this project was very late. So this jury point that the why didn't you object goes nowhere. There was no basis to object. Affan was obliged to follow instructions. A different point could be made. Why didn't you put your hand up and say this is going to cost more? And we did. Firstly, we had to wait for what the actual design was going to be. So that was only known when Visual Mockup 5 was finally approved. And what we see at page 55 is at the moment Visual Mockup 5 is approved, a few days thereafter, there is a notification saying, look, there's been a change that's had a time impact. As far as the direct costs are concerned, those cannot be notified until we start production. And this is acknowledged, as you see in the extract from CCN Trouble 2 and 20.2. We go over the page, Your Honour, page 56, paragraph 20.3, we see VMU 5, the visual mock-up is approved on the 25th of March 2018, and the first defendant issues this notice under clause 28.3 within 3 days. Now, look at the flip side of what the jury point that's been taken. Did BAM write back and say, what are you on about? Nothing has changed. Of course they didn't. Because everyone knew there was a huge change. And then 20.4, for the cost notification, the first defendant properly awaited the start of production and issued a notice of increased cost once they'd produced 100 panels. Otherwise, what are you going to notify? So we say it's clear. The contract said Affan should be able to size the panels as per his preference. Affan intended and priced for 9 by 2.2, and it was instructed, as per the employer's design team's preference, to build larger panels. And it gave notice of that in due course. At page 58, Your Honour, there's a section on the factual witness evidence. I've gone through some of the key evidence, and I'll leave that for you to look at. Page 65 is a section of expert evidence. Now, there is very little actual need for expert evidence, because whether or not there was an instruction to increase the panel sizes is a question of fact. And to her credit, despite spending some quite long passages in her report looking at the meeting minutes, Ms. Kinderland accepted that she couldn't opine on what had factually happened. You'll have my submissions that Ms. Kinderland didn't offer a good explanation for why, having decided to delve into the meeting minutes, she didn't mention CCN treble 2, but I'm not going to take that any further. Paragraph 22.2, the only possible technical issue raised regarding the panelization was a claimant's case that was somehow you had to go floor to floor because you couldn't rest structurally the panels anywhere else on the structure. And I've given you the quote from where Ms. Kinderland said she has no basis for supporting that. But we then come to the second largest variation, which is hexagonalization. It's dealt with at section 23. I'll let you read that section in due course, Your Honour, but this is page 68.
Sorry, I'm just very surprised how the original pleading came to be phrased the way it was. Because the original pleading is that each hexagon was separate, and it said there was 1 million of them, which I find extraordinary. And I can't really understand how your client could have allowed that pleading to have seen the light of day.
I'll seek. Someone's going to send me instructions out, Your Honour, but I believe that's been corrected.
Well, I know, but the very fact that it was pleaded that way disturbs me slightly, because it's patently untrue, and your client clearly knew what the hexagonalization was, that it was just scoring within the steelwork. It's an extraordinary suggestion that you would have 1 million different hexagons, all presumably welded together.
Your Honour, I'm going to seek some instructions if there's anything further to add. We are not pursuing that.
I know you're not pursuing it. Yes.
Yes, I'll seek some instructions if there's anything further we wish to add, other than to apologise for the error.
Mm-hmm.
So at page 68, paragraph 23.1, we've set out what is clear evidence.
I'm afraid I've lost vision again, and I missed about several minutes of the oral hearing. But I'm not worried about that. I can have a moment to get the vision back.
You want to take a 5-minute break?
Of course.
Okay, we'll just break for 5 minutes.
Well, I've had some adjustments made for me and I'm back on a laptop, which I'm content with.
Good. You ready to continue, Mr. Hussain?
Yes, Your Honour. I just want to draw your attention to page 68 of the defendant's
Yes.
closing and the quotation. I'm not going to go through the long quotation, but the quotation from CCN Trouble 2, which is a clear contemporaneous note from the claimant's own personnel that hexagonalization was a change to the work instructed on behalf of the employer for a set of reasons. I'm not going to spend too much time on this section. That brings me briefly to the issue quantum. The reason I said briefly is that there is a large measure of agreement between the experts. So if we go to page 73, there are two methods of quantum. Item 26 is when you measure using the valuation rate in Annex 3 of the subcontract. The reason you would do that is if you found there was no variation. And if you did that and you gave credit for the call on the bonds and the sums already paid, it would lead to a significant payment due to the first defendant. There is an alternative calculation that Mr. Kenyon has done based on what he calls a progress based on the bill of quantities. We say that there is no basis for that. The contract is very clear about how stage payments are to be calculated. But even if one could deviate from the contract, if we go to the, just bear with me because I want to get the reference. It's the presentation from Mr. So if we go to file 23, please. And then we go to Mr. Atherton's presentation at page 6. Expert presentations, please. If you go to GA presentation, please. Page 6. This is the alternative valuation Mr. Kenyon does, is he takes these percentages complete noted in an employer's monthly payment certificate at face value. That's not what the subcontract provides for stage payment. But equally, as we look at the next page, and I think Mr. Kenyon accepted this, he has no idea whether these percentages are correct or what the basis for them is. He simply lifted them off these certificates. So we said that the alternative valuation must be incorrect. So that's one way of measuring quantum. The other way, if we go back to the defendant's closing at page 73, is at item 27. If the variations were established, the experts have agreed to a large extent the as-built valuation of the works. Now, it's suggested in closing that somehow this valuation is global. Your Honour, the word global is used far too often, far too loosely in my submission. But if the suggestion is that it's not, that this is somehow some kind of mop-up claim, bear with me. If we, that's not correct. So if we go to the first joint report, which is in file 19 of the electronic bundle, Yeah, that's it. And if we go to page 29, so the experts' valuations based on this is paragraph 6.1.1, the experts' valuations based on the as-built element of D1's variation claims, which is an approach to valuation set out by GA in GA2 breakdown as follows. And we see that firstly, the claims are very specific, that they are measuring particular parts of the works. It's not a global claim, it's itemized. And if we look at the method that Mr. Atherton adopts in his second report, we need to go to file 16. Page 55. I'm not going to go through the details of this report, but just by way of example, what Mr. Atherton did, and then the experts took forward jointly, was that he looked at the IFC measures, and then he looked at the as-built measures using the CATIA outputs. So the suggestion that this is some kind of pie in the sky figure, which is what a global claim pejoratively suggests, is just incorrect. This really is looking at actual quantities. If there was a different as-built method, then obviously it was up to Mr. Kenyon to propose how the variation should be measured. What he didn't propose that, he was able to use Mr. Atherton's method. The last point being made, which I'm struggling to understand, is another, what I will call a gotcha point, that because the experts have agreed what sums were expended by the claimant during the works, that this somehow should be set off against sums due to the first defendant. That's not correct. First defendant did not undertake to carry out the subcontract works for free. That shouldn't need to be said. To the extent that the claimant expended sums, if the full subcontract price, however, is to be adjusted, were to be paid, then obviously the first defendant wouldn't get the full subcontract price. It didn't carry out all the work. But both sets of valuations carried out by the experts relate to the work carried out by D1. There is no basis, whether one is looking at stage payments or as-built valuations, to conduct a set-off against that. What the claimant seems to be doing is finding a backdoor for its claim for the extra over cost of the works. The experts, when asked to look at the legalities, they've looked at and agreed the sum spent by the claimant. You have our points on interest. We have explained why in our submission 9% should be the basis, but this is not an exact science. We're going to be in the court's hands to some extent, and the claimant has suggested 5%. So I've just heard back on the point of curiosity you asked me about, Your Honour. Again, apologies for that. It was not a deliberate mistake, but it was a mistake, and it was corrected in cross-examination. I'm not sure. There's not much more I can say on that, Your Honour, other than apologise. Can I assist you with anything further?
No, thank you very much indeed. Good. Right.
Can I just make a couple of very points? The first is you asked me about Mr. Haslam's statement. And
yes.
On the CATIA model, can I just refer you to paragraphs 21 to 26 of his statement, which set out in full what he was saying. And the second point is that Mr. Hussain suggested that, well, Horizons should have been told that there was a problem with the inspection. And I've had it confirmed, as I knew to be the case, that Mr. Blakeway of Horizons was at the inspection with DLA Piper and they were all there, and they all knew what was being said about the unavailability of the model.
Right, thank you. Okay. Anything else from either council?
Well, no, I just say thank you very much for bearing with us when we got overrun rather a lot. But
That's okay. That's okay. We had the time. Well, thank you again, both for your submissions and closing and the written closings, which were extremely helpful on both sides. And as I say, I'm grateful for those. You won't be surprised that I will have to take some time to prepare my judgment in this case. I hope very much to get it out as quickly as I can. And that's really it. Just in terms of costs, presumably we will discuss the issue of costs once you have my judgment.
well, that's what we agreed.
Sorry to
Yes.
yes, sorry to run back the clock. I'm just checking WhatsApps. Mr. Blakeway's instructions to me is that he wasn't. There was no complaint put to him at the inspection about what was being shown or not shown.
Okay,
So,
right. I think we can close that chapter. Thank you. Okay, so I will prepare my judgment, and I might circulate it in draft to council only to make sure that I haven't made any gross howlers. And then, excuse me. And then we'll consider how to deal with costs. So I think with that, we can close today's session. Thank you very much indeed. Thank you. Goodbye.